The hearing is on the matter of CFI 003-2022 before Justice Lord Angus Glennie and is being held by way of video conference. Any orders or directions made after or during the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The claimants are represented by Clyde & Co. The lead counsel is Nicholas Craig QC, and the defendant is represented by Holman Fenwick William Middle East LLP, and the lead counsel is Gregor Hogan. Thank you.
Thank you very much. Mr. Hogan, it's your application, I think.
Yes, my lord. As the Court Associates just said, my learned friend, Mr. Craig, Queen's Counsel, appears for the defendant, the claimants and the respondents to my client's application. I appear on behalf of QATAR Insurance Company. My lord, as you'll have seen, there is perhaps a preliminary application that we need to deal with first, which relates to expert evidence.
Yes.
Before we move on to the substance of today's hearing. The nub of the matter is that my clients seek to rely upon an expert report of an onshore insurance expert. And by onshore, I should make clear at the outset that I mean...
It's a well understood expression.
Well, I only say that, my lord, because the last time Mr. Craig and I were in front of one of the other judges of this court, there was some confusion at the outset as to what was meant by onshore and offshore, but I hear what your lordship says. The application, the background to the expert evidence application is that my instructing solicitors filed the expert report under cover of a witness statement from one of my instructing solicitors. Yeah. Objection was then taken to that by what I'll call the reinsurers for ease, on the basis that permission hadn't been sought. There were then directions issued by the registry, I don't know whether they were on your lordship's instructions or not, for an application for permission to rely on expert evidence, which was filed, and that application note is at page A18 of the bundle. Sorry, that is not right. Sorry, apologies, my lord. Sorry, it's tab 18 of the bundle A, which is page A588. Apologies.
Yep.
And the witness statement in support of that from Mr. Barlow is at tab 20.
Yep.
Insofar as one takes the application on its face, I can't deny that it came late. The application was filed on the 14th of July. We say that the reason that application was made late was because, as we say, as I said, my clients take the view that it wasn't necessary. Excuse me for a moment. I'm just going to close the window in case the noise of the lorry is outside. Apologies, the Lincoln's Inn gardeners are sprucing things up. On the basis that the evidence was required in order to respond to what effectively amounts to expert evidence in the witness evidence of Mr. Beswetherick, who's a solicitor and partner at Clyde & Co., which was filed in response to the jurisdiction challenge.
When was his evidence filed?
His evidence was filed in accordance with the court deadline.
Yes,
I will just I don't want to miss that on the 29th of that. His evidence is dated the 29th of March.
Yeah, and your evidence was filed in July, is that right?
That's correct, my lord.
What accounts for the three and a half months gap?
The twofold. One was taking stock of the evidence that had been filed, and secondly then was the process of identifying and instructing a suitable onshore expert. That has taken some time. Those are my instructions. As I say, I can't get away from the fact that the evidence did come late, but in my submission, there's no real prejudice caused to the reinsurers on that, and I say that primarily because Mr. Beswetherick's defence of his evidence is effectively that, well, the matters he talks to, which is the frequency with which insurance disputes arise before the onshore courts, as well as the approach of the onshore courts to the application of foreign law. He says, well, those are all about the practice of the onshore courts, and they're all common knowledge to all lawyers who operate in the UAE. And what I would say is that the evidence that we have filed is evidence as to the practice of the onshore insurance industry, all of which is common knowledge, and you can see that from the expert's report. So I say what's good for the goose is good for the gander. They can't have it both ways. Insofar as we're expected to rely upon what Mr. Besweatherick says as being the common practice of the onshore UAE courts, I don't see. It's difficult to see why we ought not to be able to put forward what we say is the.
That might well be a very good argument if you'd lodged it at roughly the same time or within a short time thereafter. The 3.5 months late and a week before the hearing.
I see the force in that, and as I say, I'm not seeking to deny that it came unfortunately late. But my overarching submission is that the evidence that is in that expert report will substantially assist your lordship in understanding what is, in my submission, the absolutely crucial commercial backdrop to this dispute and the nature of reinsurance. The practice of reinsurance as a form of fronting insurance within the UAE, and that's particularly of significant public policy importance, I would suggest, insofar.
Please press 2 for all other IT services. Please wait while your call is being transferred.
Is that one of you or us?
It's not me. I saw another one of the little circles flashing, so I think it was maybe someone else. Sorry, I'll start that again. I would also say that the evidence will assist your lordship when it comes to the substantial public policy importance that your lordship's judgment may have. Fronting insurance is the only way for reinsurers, such as the claimants in this case, to effectively directly insure risks in the onshore UAE. If it weren't for the availability of fronting insurance, it would have been impossible for these claimants to have insured any of the risk at the direct insured United Arab Bank UAB, because they aren't registered with the onshore insurance authority. Therefore, insurance companies such as my client, QIC, are an essential linchpin to the ability of foreign insurers to insure onshore risks in the UAE. And to the extent that there is a bifurcation between the applicable jurisdiction between the reinsurance contracts and the contracts of direct insurance, clients such as mine are left in the entirely invidious position where they take on 0% of the risk under the fronting arrangement, or are supposed to take on 0% of the risk in the fronting arrangement. They get paid a relatively small fee compared to the premium paid to the reinsurers for doing so. But then they're left in the position that my client potentially finds himself in, where one court of the UAE, in this case the Dubai Court of Cassation, finds them liable to the direct insured. And then the reinsurers, who are in fact really meant to be the insurers all along, suddenly turn around and say, well, no, we're going to go off to the DIFC courts, where we think we'll get to have a tactical advantage. Ask those courts to apply a different law, different procedure, and come out with a different result.
If I understand your skeleton argument correctly, one solution to all this potential problem is it called a cut-through arrangement? Sorry, you think it's what?
Yes, I think it's I refer to it as a cut-through agreement or a hold harmless arrangement. But yes, one or the other.
It's called a cut-through, which I think on your own submission means that the ultimate insured, the underlying insured, can go direct to the reinsurer.
Yes, and
if that happens, that is the solution to your problem, isn't it?
Yes, my lord. In the ideal world, that would arise in every single contract. But as you'll see from the expert report makes clear, in the evidence in support of my client's position from Mr. Krishnan, is that it is not infrequent for fronting insurers where they are satisfied that the contract of reinsurance and the direct insurance contract are on back-to-back terms. And by that I mean, and I should clarify, both that the terms as written are identical or substantially identical as between the two contracts, but also their meaning and effect. In those circumstances where the fronting insurer is satisfied, they may forego the requirement of a cut-through or a hold harmless arrangement.
My point is simply this. You use this expert evidence about the fronting arrangement to say that if a decision goes one way, the whole of the insurance, reinsurance business in the Middle East is thrown into disarray. But it's not, because they can insist on the cut-through arrangement.
And that might well work going forward, but that doesn't cover situations such as this, where you have a very now a relatively historic contract, and it would seem to me that quite possible that reinsurers such as or in a similar position to Mr. Craig's clients would not wish to lose the benefit they have currently, if your lordship were to rule against my client, of having the two options, trying to have both the cake and eat it. I accept that going forward, that would be the ideal scenario, but my submission would be that if one looks at the history of jurisdiction disputes before this court, it's not always universal that onshore actors who are unaware of this court's jurisprudence and don't keep up with it, and who perhaps don't have the services of DIFC registered lawyers and solicitors, will be left in the invidious position where they don't know that this court has expanded its jurisdiction, and are left in a situation which is entirely uncommercial and not one that they ever would have agreed to. So I accept your lordship's point wholeheartedly that in the ideal world, firms of solicitor would send out a bulletin and change all their precedents, and so would insurers, fronting insurers. But the reality of this jurisdiction and the UAE is that doesn't happen when this court gives judgments which are seen to expand the court's jurisdiction. And I'm not making any. That's not me making any criticism on that front.
Right. So is that what you want to say at the moment on this point?
I think your lordship has the point that it goes to the nature of the fronting arrangement and how that operates in the UAE.
Well, thank you, Mr. Craig. What do you say about this application?
My lord, thank you. We have 4 reasons why it shouldn't be permitted. The first is that the application is made far too late. The defendant's application challenging the jurisdiction of this court was filed on the 22nd of February 2022 with the supporting witness statement of Mr. Krishnan, and no attempt at that point in time was made by the defendant to explain fronting arrangements or how they operated or how that might affect the jurisdiction position. The claimant filed its evidence in reply, being the statement of Mr. Biswetherick, on the 29th of March 2022, as has been said. The defendant then asked the claimants for 2 extensions for the purposes of filing its evidence in response, and ultimately it had until the 17th of May 2022 to file its evidence in answer, and we can see that by, we don't need to go to it, but that's the consent order, which is at page A35. So we say, to the extent that the defendant considered that it needed to adduce expert evidence by virtue of anything that had been said in Mr. Biswetherick's statement, that 2-month period gave it ample opportunity and time to do so. And that is particularly given the fact that the rules of this court at 23.16 make clear that any application should be made as soon as it becomes apparent that it's necessary or desirable to make it. There is no reason that it was not done at that time, and no reason has been given in the evidence in support of the application as to why that application for expert evidence was not made at that time. No attempt has been made to explain why they failed to do so, and what Mr. Hogan just said orally is not supported by the witness statement of Mr. Barlow, which was filed in support of his application.
So which aspect of what he said is not supported?
The fact he claimed the reason he claimed there were reasons as to why the application was filed late, and that included a statement to the effect that they couldn't find a suitable expert. And that is certainly no feature that doesn't feature in the statement of Mr. Barlow. No explanation is given for the delay. But the consequence, of course, of the fact that this application was made only 1 week ago is that the claimants are prejudiced. First of all, it's had an impact upon their preparation for this hearing, but more significantly, they cannot, of course, adduce expert evidence themselves in response. And that is what Mr. Beswetherick states in his second statement at paragraph 16, page A623. I don't think it's necessary to take you there. The second reason we say it should be refused is that the evidence of Mr. Al-Shawaheen is not reasonably required to resolve the proceedings, as is a requirement under the rules of this court at 31.12. The question on this application is whether on the proper construction of the reinsurance contracts in issue, this court has jurisdiction, and also whether in any event it has jurisdiction by virtue of one of the gateways under Article 5A1. What might or might not be common practice among insurers or reinsurers where fronting is involved is irrelevant. The focus in this hearing is on the contracts at issue in the dispute.
Mm-hmm.
And additionally, in that point, Mr. Hogan said what is said in Mr. Al-Shawaheen's statement is common knowledge. So how can it be necessary to produce expert evidence on matters which are common knowledge? The third reason to exclude or to not allow the application is that Mr. Al-Shawaheen does not have expertise relevant to the issue on which he is saying he's giving expert evidence. If one looks at Mr. Barlow's statement in support of this application at page A594, and again, I don't know whether it's necessary to turn it up or whether I can just read it out at paragraph 13. It says, pursuant to RDC 31.15, the defendant seeks to adduce expert evidence in the field of onshore UAE law, specifically the treatment of fronting arrangements and jurisdiction clauses contained in insurance and reinsurance policies in onshore UAE. Now, evidently, an expert can only give expert evidence on matters which they are suitably qualified to give that evidence. And as you'll know, the protocol for instruction of experts to give evidence in civil claims, which is of application in this court, requires that to be the case. Mr. Al-Shawaheen is not a lawyer. He has no requisite knowledge or experience to comment or give evidence on the field of onshore UAE law. So that's my third point. Fourth point is that the evidence to which the report is said to respond is not expert evidence. The paragraph 61 of Mr. Beswetherick's statement, which is at page A303 of the bundle, makes, so I'm just trying to find it, case lines, apologies.
You just learned how to find a page.
Paragraph 61, he sets out 5 points under the paragraph. The first is, he says, the onshore UAE courts have very limited experience in dealing with reinsurance disputes. After having had my colleague, Mr. Fatty, a senior legal researcher, search the available resources, I'm not aware of any reported cases that involved or made relevant determination in relation to reinsurance contracts concluded between UAE-based fronting insurers and London or other international reinsurers. So that is a statement effectively of fact, having carried out an investigation of those resources that are available. The second point is, he says the onshore UAE courts will not generally apply foreign law, which has to be proven as a matter of fact. There are practical issues with this approach, including the parties not generally permitted to submit their own expert reports. Now, that is not disputed, as I understand it. And if you look at subparagraph D, you will see that the further reference is in other courts in the UAE proceedings are conducted in Arabic, operate under a civil law system. As set out above, onshore UAE courts will not generally apply any other law than the civil law of the onshore UAE, and the UAE Federal Supreme Court has refused to apply an express choice of English law on the basis there was no proof of the law to be applied as a material fact. So in other words, that statement that he makes is by reference to a decision. Subparagraph C.
Hang on, just so I understand. D. If there is no evidence, if there was no evidence or proof of English law, then you wouldn't expect the UAE Federal Court to apply English law. It's the same as the reverse situation.
Yes.
So what's the problem? What does D tell us that is significant?
Well, I think that the fact is they will. I mean, the point generally, I think that they will ignore choice of law clauses. I mean, that's the and that decision.
That's not what D says. D gives an example of one case where, because there was no evidence of English law, the UAE court didn't apply English law, which is exactly the way the English courts would react in the reverse situation.
Yes.
Yeah. Okay. What about C?
C.
What's the waterfall provision?
Correct.
What is a waterfall provision?
It's the priority, or basically with which this court accords precedence to various things. So you look first of all as to whether or not it satisfies question one, and that's the most that takes priority. And if it doesn't satisfy that, then it falls down to the next level, and it's ascertains whether or not it satisfies that.
Right. Okay.
I mean, we can look at that, but as I say, I don't think it matters for the purpose of this argument. This is purely looking at what he is saying and whether or not it raises issues of civil UAE law. And as I say, this point is obviously purely directed at the DIFC courts, nothing to do with UAE civil law. Right. And equally, subclause E is a reference to the jurisdiction clause and the fact that on its terms, no distinction is made between different courts of the UAE. So it's talking simply about the jurisdiction clause itself, and again, doesn't raise anything about the position in the civil courts in onshore in the UAE.
Right.
And in relation to those matters, Mr. Besweatherwick is, contrary to what's said by the other side, qualified to provide evidence in any event on UAE civil law.
Can you remind me of his qualification on that?
Yes, it is at, if you could turn to page 624.
A624.
A624 at paragraph 20. I'm just trying to find. I'll try and find the actual paragraph itself, so I can just. So it provides. So he says that he is registered to practice as a legal consultant in Dubai in accordance with Article 6A of Administrative Resolution number 234 of 2015, and the definition of legal services, this is paragraph 21, includes providing legal opinion and advice. The only prohibition is on him appearing in the civil courts of the UAE. And then paragraph 23, DLD requires legal consultants to complete training courses as part of its continuing legal professional development. These courses include sessions on aspects of UAE law. Legal consultants in Dubai are therefore trained on UAE law and entitled to advise on comment on it. And it says, paragraph 24, I am duly registered and listed on the DLD database of legal consultants.
I see. Yep. Thank you.
So for those 4 reasons, we say this application should be dismissed.
So tell me this, the main point of the expert evidence sought to be adduced is to deal with the question of fronting.
Yes.
You say you haven't had time to get a witness to deal with that in a statement at least, but you've had a week in which you can discuss with your clients the question of fronting and the practice and so on. And even though it may not be in formal terms, you must have a position as to whether you actually disagree with it.
We do disagree with it in a number of respects. First of all, the alleged cut-through arrangements that are spoken of is just, with respect, a nonsense, because that would offend against the regulatory regime in the UAE, because that would effectively be seeking to circumvent the regulations which prohibit a foreign insurer from underwriting direct insurance.
Yes.
It's going to take you, I mean, when we come to submissions in due course, we will see that the arguments advanced in favour of this so-called cut-through and hold harmless agreement don't stack up on the defendant's evidence. The hold harmless agreement doesn't say what the defendants have argued that it does say.
Yes, I see. And if I were to allow this evidence to be adduced, you'd be able to answer it in submissions, even though not in evidence.
I'll just need to take instructions on that.
Thank you. What I'm minded to, let me tell you this, what I'm minded to do is unfortunate, but I don't want to. One solution, if I were to allow the evidence in, would be to adjourn or discharge today's hearing and fix another one, which would be expensive and a waste of everyone's time. The alternative is to allow it in de bene esse, or even to defer my decision till I finished hearing the argument and then make a decision as part of my ruling in the case, which would work provided you were satisfied that you were able, even without an expert evidence, to address the issues in submissions, which I could take as they seem to me to be persuasive or otherwise.
The instructions I've got is that we can't respond to all aspects of it as it stands.
Right. Okay, so those are your submissions, are they? Again, in opposition to the application to adduce the expert evidence.
Yes.
Yeah. Mr. Hogan, was there anything else you wanted to say?
I would only limit myself to a few points. It's suggested that that the evidence, Mr. Sawahan, is not able to opine on UAE law, but what Mr. Craig didn't refer to is the fact that Mr. Sawahan is a registered expert with the onshore courts, and what that means in onshore practice is that he is sent away effectively by the judge to assess the claim on its facts and as a matter of law, and provide an expert report to the judge as to whether or not the insurer is liable to pay out under the insurance contract. So he is well versed in matters of UAE insurance law and UAE court procedure. I would also make the point that in terms of Mr. Beswetherick's qualifications, I don't dispute that he is registered with the DLAD, as are all solicitors who practice in the DIFC. Mr. Craig slightly skated over the crucial proviso as to what legal services are in that context, which include not only appearing but also pleading matters before the DIFC courts. The Dubai courts. Apologies. That in effect fatally undermines.
Pleading is used to mean making submissions appearing orally, isn't it?
Well, in the onshore context, there are very often there'll be no oral hearings at all. So it effectively is putting the whole of the case in writing, and that those are my instructions. And so far as Mr. Beswetherick is seeking to comment on the practice of the UAE, of the onshore UAE courts, of the onshore Dubai courts, I would say he's handicapped in that regard because he can't actually do it himself, and he would have to rely on either his colleagues in Clyde & Co who are Dubai qualified lawyers, or would have to seek outside counsel, as quite often solicitors firms in the DIFC choose to do, from the onshore legal sector. And finally, I would say that Mr. Craig's submission was that the court has to focus specifically on this particular contract and what these particular parties meant when they entered into the jurisdiction clause in the reinsurance contracts. I don't dispute that, but DIFC law follows English principles of contractual construction, and I can take your lordship in due course to a useful summary of that from Mr. Justice Popplewell in the English High Court. But it's very clear that the commercial consequences and the commercial background and backdrop to a contract are relevant matters that the court will have to take into consideration when deciding what these parties meant. It is completely contrary to the whole thrust of the English case law, the extensive English case law on contractual construction, to suggest that you divorce and remove the contract entirely from its context when interpreting it. So I say that the evidence of the expert report is important to that process your lordship will have to carry out.
Thank you. Well, what I'm going to do is what one of the options I hinted at to Mr. Craig. I'm going to defer my formal decision on the omission or otherwise of the expert evidence. I'm going to proceed with the hearing on the basis that it's in without prejudice to that final decision. One of the factors I'll take into account at the end is whether I'm satisfied that the issues have been adequately explored on both sides, including by oral submissions from Mr. Craig. If there are aspects at the end of it where I think the evidence is important, ought to be adduced, but it requires to be answered, or at least an opportunity to answer it, I will ask the parties to address me in writing before reaching my final decision. So proceed for the moment on the basis that the evidence is in, but without prejudice to my final decision on that point. But Mr. Craig, feel free to make submissions on the basis of your instructions as to what you say is inaccurate or otherwise about that expert evidence. Is that what I'm intending?
My Lord, thank you. I mean, what I would say is obviously I will respond. I mean, I'm not going to go through that report wholesale and deal with it, as it were, during my submissions. I'll just respond to the extent Mr. Hogan. Yes, to the extent Mr. Hogan relies upon it, I'll respond accordingly to the extent I can.
And as I say, if I feel at the end that you have been disadvantaged and you need further time to deal with a particular aspect, then I will provide the opportunity before reaching a decision on the application. Thank you very much. Right, Mr. Hogan, is your application.
My lord, will you just excuse me for one moment? The plug that my laptop was plugged into isn't actually working in this conference room, so I'm just going to dash around the table and plug it in so I don't lose power on my laptop. Excuse me. Apologies. Thank you. My lord, before we begin, it might be helpful to have a steer from your lordship as to how much you've been able to read in advance of the hearing.
I've read the skeleton arguments quite carefully. I've skimmed through the witness statements. So if there's anything you want me to focus on in the witness statements, you better at least point it out to me by reference numbers, but they're quite long.
Yes, no, I just wanted to, I can take the sort of factual background then and a bit of a canter. My lord, my client QIC is an insurer which is incorporated and headquartered in Qatar, has a branch in onshore Dubai, but otherwise has no connection to the DIFC. It's common ground that the reinsurers are incorporated and domiciled in England and Wales, and you have the registered addresses of the reinsurers at paragraph 4 of my skeleton.
So just a point I wasn't quite sure. Your clients have a branch in DIFC, do they?
No, in onshore Dubai.
Onshore Dubai, sorry. Yeah.
Okay. Onshore Dubai, they have no connection with the DIFC and aren't regulated by the DFSA.
Yep.
The direct insurance contract here is a comprehensive crime insurance policy, which was written in favour of UAB, the bank, for 2014-2015. Unfortunately, this morning I noticed it's not in the bundle, but I've quoted the relevant clause for present purposes in my skeleton argument at paragraph 6. And I will certainly make sure that the policy is uploaded to case lines after the hearing, so your lordship has it. But you can see there that it refers to any disputes arising out of and connection with this contract are subject to the exclusive jurisdiction of the UAE court.
Yeah.
And I ask your lordship to keep that wording in mind when considering what I say about the back-to-back arrangements. QIC reinsured 100% of the risk under the CCI policy with the reinsurers. I believe that's now accepted and now common ground. The reinsurance itself was a facultative reinsurance arrangement and was effected over 5 relevant layers of reinsurance. And I will gratefully refer to my learner friend's skeleton argument, which at paragraph 4 sets out those various layers and the parties to those various layers.
Yep.
If one takes the primary layer of insurance, that is at that starts at page A44 in the bundle.
Yep.
And if one then scrolls down to A48, one can see the choice of law and jurisdiction clause, but I think both myself and my learner friend have quoted it in our skeleton arguments for ease. There's a further jurisdiction.
It's the same in all the various reinsurance contracts, isn't it? Apart from one of them leaves out the word united.
Yes, my lord. Yes, so they're all the same. Hence why I only take you to one of them.
Yeah.
And I don't believe Mr. Craig and I are in disagreement that the erroneous second excess layer, there's no difference in terms of the absence of the word united from the process of construction. It seems to be a typographical error.
Can't imagine there being any difference. Yeah.
Now, my lord, as a matter of background, it's QIC's case that all its communications and correspondence regarding the placing of both the direct insurance and the entry into the reinsurance contracts took place with a broker called Aon Middle East LLC, who I'll refer to as Aon Middle East. And for your lordship's note, Mr. Krishnan addresses that in his second witness statement at paragraphs 20 30 and 31, I don't think it's necessary to take your lordship to those just now. Mr. Beswetherick, who gives evidence on behalf of the reinsurers, makes a great deal of noise about another Aon entity, Aon UK. He says that entity was the broker of both the reinsurance contracts and the CCI policy. He says that because the reinsurers are based in the UK, they would have had a UK-based broker, and it's that broker who would have liaised with UAB, the bank, as the underlying direct insured. But what that doesn't account for, my lord, is that in the reinsurance contracts themselves, Aon Middle East is described and defined as the overseas broker. And your lordship, for your lordship's note, you can find that at A153. That's where the relevant provision of the contract is.
A153.
A153, that's right.
Yeah.
So, my lord, we say that there's no evidence in the very long bundle of any correspondence between Aon UK and QIC. The only potential connection is a document which is at page A527.
So you go back to A153. Is that the same part of the same reinsurance contract as?
Yes, my lord.
A44.
Yes.
Yeah. Thank you. A527.
Sorry, I was cantering ahead too fast. I'm sorry. Yeah, A527.
Yeah.
So this is the only, this is a credit note which was raised by QIC in favour of Aon Limited UK, and you can see there that that's the premium from UAB being directed back to the reinsurers under the fronting arrangement, and you can see there that the fee, the 5% commission being charged by QIC for the arrangement, is deducted from the premium that's being remitted back to England, to the reinsurers.
Wait, help me a sec. This towards the bottom, is it?
So if you see where the AED figures are,
Yeah, 43,000.
yes, that's the commission. That's the fee that QIC charged for the fronting arrangement, and is deducted from the 876,000 dirhams that initially come into it from the bank, and then it pays out the balance of 832 odd thousand dirhams.
Yeah. Okay.
So that's the only document that we've been able to find that's had any link between the Aon UK entity that Mr. Beswetherick focuses on and QIC. And I'll come on to say that we say that who the broker is and who QIC dealt with is important to the process of contractual construction. Your lordship will have to apply to the jurisdiction clause in the reinsurance contract that we just looked at. Now, as I alluded to in relation to the expert evidence application, the bank has already made a successful claim under the CCI policy against QIC. The background to that, as you'll see from the skeleton arguments, is that a fraud was committed or perpetrated upon the bank by one of its employees when that employee colluded with a third party to effectively steal money from a UAB customer. That customer was a company called Alpine, which is a Hong Kong company, but here comes the issue. That's owned by 3 Iranian nationals.
Yeah.
Three of the original reinsurers have paid out, so part of the claim was paid out, but the reinsurers are asserting that they don't have to pay on the basis of the sanctions clause, which is contained within the contracts of insurance. The Dubai Court of Cassation has now ruled against QIC and found that it's liable to pay out the totality of the claim under the CCI policy. And it was only after that occurred, and it was only after the reinsurers failed to take any steps, as they were entitled to do under the contract of reinsurance, to take control of and step in and run the litigation taking place on shore on behalf of QIC, that the proceedings in this jurisdiction were issued for the negative declaration as to non-liability under the reinsurance contracts.
Yeah.
Now, obviously, I wouldn't seek to prejudge what might ultimately happen on the substantive claim, but if one hypothesizes that the reinsurers were successful on that claim for negative declaratory relief, QIC finds oneself in the position that I referred to earlier, where despite having only charged a very small amount of money for its services as a fronting insurer.
So Hogan, I think you can take it. I've read the prejudice points.
Excellent. I can move on. That's very grateful for the steer. Well, then I'll just move on to the grounds of jurisdiction. I don't need to take your lordship, I presume, to Article 5 of the Judicial Authority Law.
Can you tell me, are they? I'm often referred to them, but I don't have a copy myself. Where are they in the bundle somewhere?
They are, my lord. They're at page D. Well, Article 5 of the JAL is at D279.
Yeah, thank you.
Now, the reinsurers rely on, in their claim form, at page A17, the amended claim form, I should say, at page A17, they rely on all of 5A, 1A, B, C, and E, as well as the opt-in provision in Article 5A2 of the JAL.
Yeah.
And I would propose just to take those in turn, because I believe the first chunk can be dealt with probably the quickest, and then move on to the substantive issue, which is the issue of contractual construction, if that works for your lordship. Just before I turn to looking at Article 5A, 1A, there are 2 other entities lurking in the proceedings who need to be dealt with. The first of those is Zurich Insurance Company Limited DIFC branch, who I'll refer to as Zurich DIFC. That Zurich DIFC is one of the entities who entered into the contracts of reinsurance on each of the layers. The QIC accepts that Zurich DIFC is a licensed DIFC establishment.
Yes.
The more tricky other entity is this entity called Talbot Underwriting, open brackets, MENA, close brackets, Limited, who for ease I'll just refer to as Talbot DIFC. Now, that company no longer exists. It's been dissolved, so it is no longer a DIFC establishment. And if I take your lordship, if I may, to page A189. This is the document that Talbot, who is the third defendant, has produced as setting out the agency. Excuse me.
Third claimant.
Third claimant, yes, sorry, third claimant, quite right. This is the document that they have produced as evidencing and setting out the agency arrangement that existed between it and Talbot DIFC. And as we'll come on to see, it appears to be the case that the third claimant, Talbot, effectively seeks to attribute the legal personality of Talbot DIFC at the time the contracts were entered into as a DIFC licensed establishment to Talbot itself for the purposes of jurisdiction. But I'll come on to talk about that in a minute. But I just wanted to flag those two entities at this stage, because they do loom large in the reinsurer's case.
But just to be clear, you accept that Zurich DIFC, who is the not a claimant but is party to all but one of the layers of reinsurance, is a DIFC entity?
It is a. Excuse me, as always, I'm having to take instructions via WhatsApp. Yes, I can't dispute that Zurich DIFC is a licensed DIFC. It's registered with the DFSA. It's an extant company.
Yeah.
So turning then to Article 5A1A, which, sorry to jump about, but that's at D279, where we were at before. I will try and avoid jumping around.
With apologies for interjecting, as will be clear from our skeleton argument, we don't rely upon Article 5.1a.
I thought that was the case, but I just wasn't sure whether Mr. Hogan had some other point to make on it.
Well, what I'll then, the reason I was going to address it is I've taken a different order then. My learned friend seeks to rely on 5A1E, which, as your lordship knows, is the sweep up provision.
Yeah.
Upon which various additional jurisdictional gateways have been opened up by the court in recent jurisprudence. Now, what's then relied upon as the relevant DIFC law is Article 19 of the court law. Now, Mr. Craig will correct me if I'm wrong, but I don't think that's in the bundle. But I'm very happy to rely upon the quotation of Article 19 in his skeleton argument.
The skeleton.
Sorry, excuse me. It's a 22, my lord, 22.
Paragraph 22.
22 of Mr. Craig's skeleton argument.
Yeah, yeah.
Yeah, and one's looking at 19A.
Could I ask your agents to get it onto the case lines thing as soon as they can?
Yes, they'll be listening in, so they'll action that straight after the hearing. And I believe reliance has been placed on Article 22, 19A rather, that civil or commercial cases and disputes involving the centre or any of the centre's bodies or any of the centre's establishments. As my lord knows, there are a number of parallels and accepted analogues between provisions of the judicial authority law and the court law. But your lordship will also be aware that the judicial authority law was amended in 2011, but the court law has never been amended and has never caught up with the judicial authority law. and on occasion this has given rise to mismatches between the different provisions. And apologies, these aren't. But does your lordship have a copy of the blue book?
Yes, I do. Yeah.
If I could take your lord just to page 2 of the commentary.
Apologies for interjecting once again. The Article 19 is actually in the bundle already. It's at page D192.
D192. Thank you very much.
Thank you very much.
Let's just find it. Hold on.
Thank you, Mr. Craig.
Yes, thank you.
Now, in the second paragraph on page 2 of the commentary in the blue book, perhaps I can just invite your lordship to read that, which starts, similar provisions appear in the DIFC court law.
Yeah.
My lord, this is a classic example of a mismatch between the provisions of the court law and the provisions of the judicial authority law. And in such circumstances, it is the judicial authority law which must trump the court law.
Show me what the mismatch is.
Well, if one looks at Article 19(1)(a) on page D192,
Yep.
one sees there that it says the Court of First Instance has original jurisdiction to hear any of the following: civil or commercial cases and disputes involving the centre or any of the centre's bodies or any of the centre's establishments.
Yeah.
If one goes back to D279.
Oh, hold on. What are we looking for?
The Article 5A(1)(a) of the JAL.
1A, right, hold on. Right.
That provides that that the Court of First Instance shall have exclusive jurisdiction to hear and determine a civil or commercial claims and actions to which the DIFC or any DIFC body, DIFC establishment or licensed DIFC establishment is a party. It's much narrower.
So I'm just looking for where you've set it out in your skeleton so I can have the two up together. I printed your skeleton.
So Mr. Craig's got the court law at page.
I've got the court law on my screen. I just want to. Here we are. Just 5A1A. Yeah. Okay.
Yeah, 16B6. Yeah, 16. Sorry. So as I say, my lord, the two are the analogues of each other. One narrower than the other.
And the narrowness is, you say, because of the word part, is a party.
Is a party. That's clearly narrower than the word involving. And was made clear in the Sky News case. The court's jurisdiction is governed solely by the JAL.
All right.
So, my lord, that then takes us back to why that's why I was beginning, perhaps inelegantly starting at 5A1A at the beginning, which is to make the very simple point. Well, two points. First, Zurich DIFC is not a party to this claim or to these proceedings.
Yeah. Yeah.
Talbot DIFC faces a number of hurdles as being the hook for jurisdiction. The first is, as I set out in my skeleton argument at paragraph 17, the court has made clear on 2 occasions in the Tavira decision and in the Serin decision that the court must determine whether a party satisfies any of the criteria in 5A1A, so is it a DIFC establishment or licensed DIFC establishment, on the basis of its current status, i.e. at the time that jurisdiction has to be determined.
Yeah.
Talbot DIFC doesn't exist anymore, so it clearly isn't a DIFC establishment or a licensed DIFC establishment. The second difficulty, which flows inexorably from that, is that Talbot DIFC, as a dissolved company, cannot and is not a party to these proceedings or to this claim.
Yeah.
The reinsurers appear to seek to get around that by saying, well, Talbot DIFC was the third claimant's agent, Talbot's agent.
Yeah.
It entered into the contracts on behalf of the third claimant. At that time, Talbot was a DIFC licensed establishment, and therefore the court has party jurisdiction over Talbot as the principal under that agency arrangement. My lord, that submission is completely unsustainable on the clear terms of Article 5(1)(a). That focuses on the...
It's my fault. I had not understood them to be relying on 5A1A for that submission. I thought they were relying upon B. Namely, it was partly concluded within the DIFC.
Well, if one looks at paragraph 23 of Mr. Craig's skeleton argument, and if I'm wrong, I'm sure he will correct me in due course.
Yeah.
There, Mr. Craig refers to Talbot DIFC being a licensed DIFC establishment. Well, that's wrong. It's not. It was, but it's not now. And therefore, under Article 19, the court has jurisdiction over the reinsurance contracts. But of course, Article 19 is not applicable because it must give way to Article 5(1)(a). In my submissions, all roads lead back to 5A1A, insofar as party jurisdiction is concerned.
Yeah.
But in my submission, it simply cannot be right to seek to transpose whatever might have been Talbot DIFC's legal status and legal personality at the time the contracts were entered into to its principal for the purposes of engaging 5A1A, which I say must be the operative and definitive provision in this context.
Yeah. All right.
Now, once one removes Zurich DIFC and Talbot DIFC from the picture, insofar as Article 5A1A is concerned, in the preceding paragraph 21 of Mr. Craig's skeleton argument, he refers to the provision in RDC 20.7. That's what in England
Is that necessary and proper party?
necessary and proper party, and you've got there the Nest Investments decision, which has been affirmed on 2 subsequent occasions recently by Justice Martin, to give rise to an independent ground of jurisdiction over parties who otherwise wouldn't fall within the court's jurisdiction. Mr. Craig, in his skeleton argument, and this is reflected in Mr. Beswetherick's evidence, states that the third claimant properly brings its claim against the defendant in this court, and therefore all other claimants are properly joined on the basis of Article 20.7 as being necessary and proper parties. Well, of course, in my submission, the third claimant has no basis upon which to bring proceedings on either on the basis of Article 5A1A, which again must be the operative provision, so that falls away. So that was all I was going to say about party jurisdiction, unless I can assist your lordship any further.
Carry on.
So I'm going to take. I was going to propose to take for Article 5A1B and 5A1C together.
Mm-hmm.
I think my learner friend and I, as I read his skeleton argument, are agreed as to the case law, which is applicable to those provisions and which has glossed those provisions. We both rely on the Al-Kafari judgment, which is at tab D, section D, tab 2.
Yeah.
And if I can invite your lordship to go down to page D55 in the bundle.
Mm-hmm.
And it might be easiest if I just invite your lordship to read paragraph 60, 60 and 63, 64 and 65. I suspect that's probably easier than me reading them out.
Yeah.
Where, unsurprisingly, Mr. Craig and I disagrees on the application of those principles to the facts of the case. Reliance again, focus again falls on Zurich DIFC and Talbot DIFC, taking them in turn. Reliance is placed upon Zurich DIFC's role in signing and stamping the various layers of reinsurance. But my lord, my submission is that what the reinsurers can't point to is an authority where the rules and acts of a third party to the proceedings have been sufficient to engage the court's jurisdiction under Articles B or C.
Say it again. I was writing something. Can you repeat that?
Yes, of course. Sorry. What the reinsurers haven't been able to do is point to an authority where the rules and acts of a third party to the proceedings before the court have been sufficient to engage the court's jurisdiction of subarticles B and C. None of the reinsurers in this case have any connection with Zurich DIFC. These are facultative reinsurance contracts where each of the reinsurers takes on a proportion of the risks on an arm's length basis independently of each other in commercial terms. And in my submission, it would be an inappropriate expansion of this court's jurisdiction for the, I see you look.
No, I'm thinking.
An inappropriate expansion of this court's jurisdiction for a party to rely on the actions of a totally independent party and their activities within the DIFC to bring any and all disputes arising out of the negotiation, entry into, application of the reinsurance contracts within the jurisdiction of the court.
Sorry, can you just help me with two things?
Yes, my lord.
Say that there's no authority where acts of a third party are sufficient to satisfy the rule. But if a principal acts through an agent, as often going to be the case that the contract might be concluded, for example, in the DIFC through an agent, you're saying that wouldn't satisfy the test in QATAR?
No, my lord. What I would say is that, as a matter of principle, it ought not to be possible for parties to refer to the actions of any other person, whether they're an agent or a principal, that occurred or happened to occur in the DIFC, where the actions of that individual have no connection to, no role in the proceedings that are before the court.
The agent has a role in executing, to use an imprecise term, the insurance contract.
But in my submission, however, where that agent is not, where that agent's principal, neither that agent nor that principal are seeking to engage the jurisdiction of the court, that shouldn't be sufficient for other parties who.
Tell me, sorry to interrupt you. Maybe I've got this all wrong. I had understood that, and I may be completely wrong, that each layer of reinsurance had a single contract subscribed by the various parties to that layer. Am I right? It's not as though they had individual contracts.
My lord, you're right. There is a single contract formally, but in my submission, that's simply a matter of form when one is dealing with a facultative reinsurance contract where different insurers take different proportions of the risk. In effect, in reality, these are all.
If they want to sue, they sue under the same contract. All parties to it. And if one, for example, take a very different situation, if one party, one reinsurer, acted in a certain way, it might involve the others in having rights. I don't know. I can't think of an example. But I mean, the actions, they're all under the same contract, and the actions of each of them affects the rights of others under the contract, potentially.
My lord, in circumstances where Zurich have taken the complete inverse view on the proper construction and application of the sanctions clause, which is relied upon by the reinsurers as the basis for their claim for negative declaratory relief.
Yeah.
Excuse me. It's my submission that the reinsurers ought not to be able, in circumstances where they are all independent insurers contracting at arm's length with each other, to rely upon the happenstance presence of an agent of one of their co-contracting parties within the DIFC as the basis for founding jurisdiction. The Al-Kafari decision is clear that there has to be some meaningful geographical connection to the DIFC, and in my submission, the presence of an agent of a third party principal, not party to the proceedings, who in fact actually has taken the complete opposite view of the contractual rights and obligations of the parties under the reinsurance contract, can be in any way relevant or an appropriate hook for engaging 5A1B or C.
Mr. Hogan, don't we construe the contract at the time it was made? And
yes.
The fact that Zurich may have taken a different view, a different line to the others on whether they're covered or not, and on the sanctions clause, is neither here nor there, is it?
Even if one yes, one does interpret it at the time that the contract's been entered into. However, one also needs to determine whether the jurisdictional provisions in Article 5A1, B and C, which focus on transactions being performed, and what's relied upon is that the contract was partly finalised, partly performed, I believe, in the jurisdiction.
I thought. Sorry, it's quite important. I must just make sure I understand your submission. As I read B, 5A1B, it covers contracts partly concluded within the DIFC.
Yes, I accept that's the plain that's the plain reading. My submission is that the court then needs to interpret what was intended by that, and in my submission, what's intended is a meaningful geographical connection between the jurisdiction of the DIFC and the parties in the proceedings before it. In my submission, in circumstances where there is what's relied upon is the presence of an agent of yes, a co-contracting party, but not in the sense that there was any sort of long-term relationship between these reinsurers. They've all taken their individual slice of the liability, and some have paid out, some haven't. That would undermine and expand the court's jurisdiction beyond any reasonable geographical connection.
Let's assume that Zurich had not been so kind and had refused to pay up on the basis of the sanctions policy. Yeah, so they were they were therefore claimants to the same litigation as we are dealing with at the moment. Yeah.
Yes.
That would surely be them suing, if you want to isolate their own position, suing under a contract made by them through an agent in the DIFC. Yeah.
I mean, I can't dispute that, but my submission is the court should focus on the particular parties and those who are convened before it.
It's the one contract. If the claim under that contract by them is within the jurisdiction of the DIFC because of 5A1B, then surely you can't say the claim by others under the same contract are not.
I'd invite the
covered by 5A1B.
I'd invite the court to take a purposive construction of Article 5A1B and C on the basis that looking at this on two fronts. Well, let me start that submission again. I'd invite the court first of all to look at the substance of these contracts, which is that yes, they might all have signed one contract of reinsurance, but in my submission, in reality, they are a series of individual contracts whereby each party is taking on a proportionate share of the risk. I would then.
You're saying in reality these are individual contracts?
Yes, my lord.
These are. Yeah. Right. And so the fact that Zurich agreed to pay, what is it? What's my schedule here somewhere? Zurich agreed to pay 27% of the fourth excess layer. Did not influence, I mean, is completely separate from the agreement of the others to subscribe 27% of the same layer.
For the purposes of jurisdiction under Article 5A1.
I thought I was taking a holistic or realistic view of the contract. I'm surely the subscription by Zurich of a certain percentage may at the very least, have some influence on the willingness of others to do the same.
I'm sorry, my lord. I don't. Could you?
Sorry.
Sorry.
I'd always thought that you go around finding people willing to subscribe the policy, and one is influenced by the fact that others have signed, and therefore it may be independent legal liability, but it's all one contract, which is dependent for its coming into being on all the insurers having agreed to sign for their share.
Yes, my lord. Sorry, I'm just receiving a WhatsApp message. Excuse me, just for one moment while I instructions whizzing through the ether from Dubai. My lord, I think you have my submissions. I don't think I can add anything to further to what I've said on that.
That's helpful, thank you. So I'm not expressing a view one way or the other at the moment. I'm just trying to find out the extent of your argument.
No, I'm used to your lordship's inquisitorial style, so that's that. I completely understand.
Right. Where do we go next?
Sorry, just one final point. I would just for your lordship to bear in mind when approaching the construction of 5A, 1B, and C is, of course, that they confer exclusive jurisdiction on this court, and so there is sometimes much made of the fact that the phrase "courts of Dubai," the courts of the UAE, may be exclusive as against the rest of the world, but are non-exclusive as within the UAE. But of course, if your lordship finds jurisdiction on Article 5A1, B or C, of course, effectively the party's contractual choice is ousted completely. Only the DIFC court can have jurisdiction. So I think in my submission, that the scope.
I take that point. It's something I wanted to ask you about, and perhaps this is therefore a convenient point to ask you. If it were the case, and I know your argument against it, but if it were the case that the signature by Zurich DIFC on behalf of Zurich Insurance meant that the case fell within 15A1B because it's partly concluded in the DIFC, just assume that as a starting point.
Yes, my lord.
That would, on what you just said, give exclusive jurisdiction on one view to the whole case, but on a different view might just be to the case by Zurich had it brought it separately. Anyway, leave that aside for a minute. On one view, it would give the DIFC court exclusive jurisdiction. There's no scope, I think I'm understanding you to say, no scope for a forum conveniens approach, or whatever. Indeed, the contract itself excludes a forum conveniens argument, I think.
Yes, quite apart from the contract, just for your lordship's note, you can read it at your leisure. At page 13 of the commentary in the Blue Book, my colleague, Mr. Wheel, addresses the decision in Banyan Tree, where and in IGPL, where the Court of Appeal has made clear that forum non-convenience cannot apply on an intra-UAE basis.
Yeah, I see. The reason I ask is because on one view, some of the points you make based on your UAE legal expert, the fronting arrangements and so on, may on one view be quite compelling, a not expressive view, but they're as of nothing if it were the case that the contract was wholly or partly concluded within the DIFC and therefore falls within 5A1B.
On the basis of the existing case law, that would be the case, and particularly so in this particular case, because of course the relevant onshore courts here would be the Dubai courts, and the Dubai courts have already dealt with the cassation brought by the bank, and of course the JAL is a Dubai law designed to divvy up jurisdiction as between onshore and offshore. So because this law says shall have exclusive jurisdiction, at least in this English translation, which I should say is all these translations are unofficial, there is no official translation. On the basis of this drafting, as applied by the DIFC courts, that would entirely oust the jurisdiction of the onshore courts. And of course, that, as practitioners know, that's why the JJC was then established as a way of trying to ameliorate the potential difficulties of the exclusivity of jurisdiction.
So if it were to be the case that despite compelling arguments, as you would have it, about the fronting arrangements and so on, all pointing to this being a case for the onshore courts in Dubai, if it were nonetheless the case that it fell within 5A1B as being partly made in the DIFC, then this court would declare the DIFC had jurisdiction, but you would still be able to go to the I forgot what, JJC?
The JJC, yes.
And ask them to deal with the matter.
Yes, on the basis of I think it's Blackhand and Lamia. It's a judgment of Justice Martin. I don't know if you're aware that the court is in the habit at the moment of naming every single case with different names beginning with L. But in one of his recent judgments, he made clear that what now has to happen is that your lordship would have to give a final ruling on jurisdiction, and then one would then also need a final ruling from the onshore courts for them to find they had jurisdiction, and then those then get taken to the JGC for determination. Your lordship's entirely right.
Yeah. So and that's where your arguments about the practice and fronting and all that might have a second life, as it were, if I was against you in this hearing.
They may yet live on, yes, in different jurisdictions.
Yeah. That's helpful. Thank you very much. Where do you want to go now?
You've seen what my lordship said in your lordship will have seen what I've said in my skeleton argument about the role of Talbot DIFC in relation to 5A, 1B, and C. I'm conscious of time, and I wouldn't want to labour the point if your lordship already has it.
Excuse me 1 second, my phone's just gone. I've got to turn it off. Sorry about that. Yes, carry on.
Your lordship has it, paragraph 37.2, page B11 of my skeleton.
37.2. Yeah.
What I say about Talbot DIFC.
Yeah.
And what I and my submission in relation to Talbot is that.
Yeah.
Excuse me, I'm just checking my note. My lord, I don't think actually, on reflection, I don't think I can add anything in light of our discussion relating to agency. I don't think that I can add anything to what's in my written notes. I would just refer your lordship to what I say at 37.2, if that is acceptable to your lordship.
Talbot's role was agent for Talbot in.
Yes.
In the same way as Zurich DIFC operated.
That's my understanding, yes, and I think that's the evidence from Mr. Biswetherick.
Yeah, I see.
Oh no, Mr. Craig's shaking his head. Apologies.
No, we'll hear Mr. Craig.
Yeah,
of course.
yeah, Mr. Craig will correct me. I don't mean to mislead. The only thing I would add about Talbot DIFC is that what's said in Al-Kufari is that in relation to 5A1C and the definition of DIFC activities, reference is made to the carrying on of a commercial activity within the DIFC. Insofar as the agency relationship is relied upon, it's not at all clear from the face of that agency agreement or agency authorization that I took your lordship to, whether or not this was in fact a commercial arrangement between Talbot DIFC and Talbot in London. It doesn't appear to have been carried on for any consideration or any payment. In my submission that some sort of payment is necessary for something to be a commercial activity, has to be carried on for profit, but you have that at 38 in any event. Unless I can interest your lordship any further on 5A1B or C, perhaps move on to the meat and potatoes of the case on 5A2.
Can you remind me, please, before you do that, when I reach a decision on this case, do I have to be satisfied absolutely that there is jurisdiction, or that there is a good arguable case on jurisdiction?
Can I reflect on that and perhaps I think given this is a final, can I come back to you on that? I don't want to mistake the test.
Right. Meat and potatoes.
Meat and potatoes. Sorry, that's a bit of a colloquial phrase. So the focus of this is 5A2. From the discussions that your lordship's had with myself and Mr. Craig, your lordship has the core point here, which is that it's all to do with fronting and fronting arrangements. I would emphasise that the centrality of the fronting arrangement to the QIC's case on construction is made very clear from the witness evidence filed in reply to Mr. Biswetherick's evidence. And if I could section A, tab 16, page A501 is the start of the second witness statement of Mr. Krishnan.
Yeah.
And if I just take your lordship onto A505.
Yeah.
Now, I'll be taking your lordship to this in some detail in due course, but I just want to flag at this stage that paragraph 23 is quite a detailed explanation from Mr. Krishnan about fronting arrangements and how they operate in the UAE. Your lordship's already picked up about the point about hold harmless and cut through clauses, etc. That witness statement was filed on the 17th of May 2022. So it's quite clear that the reinsurers have had plenty of time to consider this point. I hear what Mr. Craig is here. I heard in Mr. Craig's submission that he's going to address this point and a number of difficulties as a matter of UAE law about these arrangements. But I do note that his skeleton argument makes no discussion of fronting arrangements. So I just want to flag that that this has been on the radar of the reinsurers for quite some time.
Sorry, what date was this?
At the 17th of May.
Okay.
So, my Lord, as to the law on this, as a matter of DIFC law, I don't think that the applicable case law is in any dispute between myself and Mr. Craig. Your Lordship will be aware of the older cases on the proper approach to the construction of jurisdiction clauses in this jurisdiction. He cites them at paragraph 24 of his skeleton argument.
Give me a sec. Yeah.
And so you see there the Talim decision, the Suntech decision, and the IGPL decision.
Mm-hmm.
I don't think we need to go to those, mainly because the Court of Appeal has on 2 recent occasions given quite comprehensive judgments on the proper approach to jurisdiction clauses. So the first one I would take your Lordship to very briefly is the decision of the Court of Appeal in Goyle. And if one looks at page D at 160,
Yeah.
and one can see there at paragraph 91 that what the Court of Appeal did, upholding a very detailed decision of Justice Martin at first instance, is that the cases point to a default position in which the DIFC Court of First Instance is included with the terminology courts of Dubai along with the onshore courts. And QIC doesn't dispute that and QIC is content for present purposes with that description of the rule. And
Yeah.
but what QIC would draw to the Lordship's attention is what's said at excuse me, sorry, I've lost my place. It is what's said, for example, at paragraph 97, which was that the Court of Appeal made clear that this was not a case in which the red flag of constructional choice was raised. And then it goes on to say at 98 that the lack of ambiguity in the circumstances suffice to treat the term the DIFC courts as specific, clear and express, reposing the jurisdiction. I think the phrase, the term the DIFC courts there must have meant the Dubai courts when one reads the sentence, as reposing the relevant jurisdiction in the DIFC courts, although it may also have covered the onshore courts. And then at paragraph 100 over the page, the Court of Appeal said it must be emphasised, of course, that the construction of terms such as, quote, courts of Dubai, end quotes, and open quotes, courts of the Emirate, end quotes, will depend upon their particular context. The history of the transaction and issue of this case is central to the constructional conclusion.
Yeah.
So, my Lord, the rule is a default rule which can be rebutted and can be displaced when, as a matter of the ordinary process of contractual construction, applying broadly English principles of contractual construction, it is clear that the parties to the contract did not intend the DIFC courts to fall within the words courts of Dubai and courts of the UAE. For that latter proposition, I refer your Lordship to, it's in the bundled, we don't need to go to it, I don't think, the recent decision in Al Bahira National Insurance Company and Horizon, which both my learned friend and I appeared in, where it's in the bundle at, it's at the very end.
Al Bahira.
Yes, it will be 11, E-tab 11, Al Bahira, National Insurance Company.
D9, but E11.
E11, it may appear twice. Some of them appear twice.
Right.
Apologies for that.
What does Al tell us?
And in that case, the phrase courts of the UAE was on the basis of applying the principles in Goyle and the principles in Labika, which I'll come on to say, was found to give rise to a default position that the courts of the DIFC fell within that jurisdiction clause.
Yeah. So you're agreed on that. That basically reinforces the idea that it's a default position that courts of Dubai can include, of course, UAE can include DIFC.
The decision in Al Bahira is subject to an application for permission to appeal, but in terms of what we're agreed that I believe we're agreed as to what Goyle and Labika say on the face of those judgments, so that is the appellate authority on the approach the court should adopt. And what I seek to do is to draw to your lordship's attention the sorts of facts and matters that demonstrate that default position should be displaced in this case, in favour of an interpretation of the jurisdiction clause, which excludes the DIFC courts. It could only include the onshore UAE courts. There was never any intention to confer jurisdiction on the DIFC courts.
Yeah. Okay.
I could take your lordship to, if your lordship wishes, to the subsequent decision in Labika, which is another decision of the Court of Appeal which followed Goyle.
Is there a particular paragraph?
I'll take your lordship. If you go to page D170, please, my lord.
Yeah.
It may just be easiest, if it's not too much, for you to skim through 39 to 42 on that page. It's a useful summary of both Goyle and the Court of Appeal's own exposition of the law.
Yeah.
Thank you, my lord. So our primary submission in seeking to rebut that the default rule is set out.
Can I just ask you something? The passages you've shown me say default position is that courts of Emirates can include DIFC. Perhaps will normally include DIFC anyway, as a default position, but it depends on all the circumstances. Yeah.
Yes, my lord.
You've been at some lengths to explain the fragility of any connection with DIFC. Just Zurich DIFC and Talbot DIFC, but you say minimal. Are there any connections apart from the underlying insurance? Are there any connections with onshore Dubai in the reinsurance contracts, apart from the very fact that the underlying insured was? No, it wasn't Dubai, was it?
The underlying insured is in
UAE.
It's certainly an onshore UAE. I'm sure someone will ping through to me the correct answer. It's certainly an onshore UAE. The other connections to onshore UAE, of course, are the fact that QIC its only presence in the UAE onshore is in onshore. Well, the only presence in the UAE in totality is in onshore Dubai, where it has its branch office. The other connection to onshore UAE is, of course, the flip side of my submission in connection to the lack of connection to the DIFC, which is, of course, the QIC's only interaction with anybody in relation to the placing of this insurance was with Aon Middle East, and Aon Middle East is in Abu Dhabi. All the contracts that, all email communication, all letters, all correspondence between QIC and any broker was Aon Middle East in Abu Dhabi from its Abu Dhabi offices. The various contracts were signed and sent between those offices in onshore UAE. So in my submission, there are a number of substantive connections on the facts to onshore UAE, whereas there are none apart from these two agents to the DIFC.
But onshore UAE is a broad term covering many courts. It covers Abu Dhabi, it covers Dubai, no doubt it covers other places, I don't know. Which of those do you say is meant by DIFC, by courts of the UAE?
Well, in my submission, we don't need to show anything other than it's the onshore federal courts, and I say that because there is some debate as to whether, as I understand it, whether or not insureds, when they receive a positive or a negative judgment from the onshore insurance authority, can only take their cases to the courts of Abu Dhabi or the courts of Dubai, or whether they can take them to any federal court within the UAE. So in my submission, it is any federal onshore court, because in the context of this particular contract, a claim under the CCI policy would have to be taken to the insurance authority and then appeal to the relevant federal UAE court. So in my submission, it's not necessary for QIC to narrow down a particular court within the federal judiciary, or indeed the separate judiciaries of Abu Dhabi and the Emirate of Dubai. What's sufficient is to show that there was no intention to confer jurisdiction on the DIFC courts, or indeed any other offshore courts, principally the ADGM court.
Yeah. Okay. Yeah.
So I'm going to try and take a steer from what your lordship said about with understanding the nature of the prejudice, but clearly, be given that the fronting arrangement is the crucial plank, the primary plank, I should say, of QIC submissions on why the default rule should be rebutted. I hope your lordship will indulge me if I just take you through some of the evidence on that.
Yes.
So if I could take you first to page A505.
Yeah.
Sorry, now it's my turn for my computer to be slow. So this is the paragraph that I took your lordship to a few moments ago. Paragraph 23.
This is Mr.
Krishnan's second witness statement on behalf of QIC.
Yeah.
And perhaps I could just, again, I invite your lordship just to skim 23 and 23.1.
Okay. Yeah.
So what one has is a situation where, in this case, the reinsurers want to write insurance to the bank. They can't do that because the bank is in onshore UAE.
Yeah.
The reinsurers are not registered with the Federal Insurance Authority to do that. So they come to QIC, who acts as the front, as the middleman. They're paid a small fee, 5% of the premium in this case, but crucially, they're not to be exposed to any risk under the contract. Here in particular, because in some previous versions of this reinsurance arrangement, a small proportion of the risk was retained by QIC, but here it was 100% reinsured. And one can see that the internal policy of QIC is that there are two routes effectively to protect themselves. One is through a hold harmless letter, and the other is through a cut-through clause, as your lordship alluded to earlier on.
Yeah.
But if one then looks at paragraph 23.2 of Mr. Christian's evidence, what he says there is that on occasion, QIC was prepared not to require those provisions in circumstances where, having reviewed the reinsurance contract and the CCI policy, they were content that the contract was on back-to-back, the contracts were on back-to-back terms. He says there that the CSCI policy is subject to UAE jurisdiction with UAE laws.
So where do I see that?
If one reads 23.2.
Yeah. Oh, yeah. The last line. Yes.
Yeah. And you can see it's gone all the way up to QIC's CEO for review and approval. So that's another method, a third method by which QIC can protect itself in these circumstances, which to ensure that the terms and the meaning of the terms in the two sets of contracts, the reinsurance contracts and the underlying contract, are back to back.
You can ensure the terms are back to back. They can't ensure the meaning is back to back because they may be construed by different people.
Well, I'll come on to that. purpose of the purpose of that, the reason why that back-to-back arrangement is satisfactory to QIC is because, as Mr. Christian explains in 23.3, and I won't invite your lordship to read it, but just for your lordship's note, Mr. Christian explains that it avoids the very prejudice your lordship identified earlier, which is that the fronting insurer could be faced with two different judgments from two different courts, which leave it stuck in the middle, having to pay out under the direct insurance policy when it will have no reinsurance coverage under the reinsurance contracts. Now, my lord, if I could take you now to Mr.
This is a problem, isn't it? That in the underlying CCI policy, it is no more specific than UAE courts, UAE law.
Well, perhaps
exactly the same as you've got in the reinsurance contracts.
Well, perhaps, my lord, I'll then. The reason why that's not the case, in my respectful submission, is because one needs to understand the context in which the direct insurance is regulated and litigated. So if I could take your lordship to 23.4 of Mr. Christian's evidence, which is just over the page.
I've got it.
And in that paragraph, he explains the operation of Article 110 of the onshore. Sorry, I'll just let your lordship read it.
Yeah. Yep.
I'm whole. Sorry, I just need to check a reference I need to check my next reference because something was added to the bundle while we've been going on. If I could take your lordship to please to page D553.
Yeah.
This is the provision which deals with dispute resolution of insurance contracts governed by the federal insurance law, which is not I don't believe is in dispute, is the case in relation to the primary and direct insurance here, the CCI policy.
Right.
And what one sees in Article 110(1)(c) is that if any dispute arising out of a claim under an insurance policy, the concerned party shall have the right to submit a written complaint to the authority, which shall also have the right to ask the company to provide clarifications.
Yeah.
It then gets sent off to a committee, a dispute resolution committee. That committee will then make a decision for the settling of disputes arising from insurance policies. That's Article 110(2).
Mm-hmm.
Article 110(3) makes clear that claims related to disputes cannot be accepted by the onshore courts before a complaint has been filed to the insurance authority and dealt with by the dispute resolution to the resolution committee. So it's inadmissible before this procedure.
Are they onshore courts in Rule 3?
I've never understood it's been disputed that refers to the onshore. That's the onshore courts. I mean, this can't be. Well, it can't be. I mean, it can't be the offshore courts because the offshore courts aren't bound by Article 110(3). It's a federal law which is excluded as a civil and federal law under the federal law number 8 of 2004. It can't apply.
Right.
Courts.
I mean, what you're showing me is a structure whereby an insured who isn't satisfied with the decision of the insurers can make a complaint in the way described in this article.
And then, yes, my lord.
But it doesn't require him to make a complaint.
Well, he can't. The insured can't bring proceedings until he has gone through this procedure.
Your analysis, they can't bring proceedings in the onshore courts. What's to stop them going to the DIFC court if they have agreed to do so?
My lord, because the only opt-out from this provision in these rules, and I get the article reference. The only provision is the only opt-out from this procedure is in relation to arbitration. It's otherwise mandatory onshore. Parties can't opt out of it. The only opt-out is in arbitration.
If you look at 1C, should a dispute arise, the concerned party shall have the right to submit a written complaint. That doesn't sound mandatory. I mean, it's always dangerous construing these as a.
There are English translations as well.
It doesn't appear to be mandatory.
My instructions are that the onshore courts. Well, if one looks at Article 110.3,
yeah,
assuming for present purposes that does refer to the onshore courts, claims related to disputes arising from insurance policies may only be accepted after bringing these disputes before the committee, so that the onshore courts are barred from hearing disputes.
Yeah, does it bar the DIFC courts?
Well, my submission, it does, because Article 100, sorry, I'm just going to get the relevant rule. There is a rule, if your lordship would, I'm just pinged off a message to get the reference. If your lordship can take my word for it at the moment, there's a rule which specifically provides for an opt-out from this provision where there's an arbitration agreement.
Yeah.
There is no provision in UAE insurance law for a party to opt out of this regime by opting to submit their disputes to another form of court resolution procedure. They can only opt to submit their disputes to arbitration. And so in my submission, what these provisions show is that insofar as UAB, the bank, and QIC would have been concerned at the time of contracting the CCI policy, is that the phrase "the UAE court" in the CCI jurisdiction clause could only ever have meant the onshore courts, because they knew and would have known as sophisticated parties that there was a mandatory regime providing for the resolution of disputes through this mechanism. And I say that because once one has one's decision from the insurance authority, one needs to go off and get it enforced by one takes it as a judgment to the execution judge onshore in order to enforce it as a judgment. So in my submission, that is a crucial background fact in informing and addressing your lordship's question as to why the meaning of courts of the UAE would always have had a consistent interpretation and understanding insofar as onshore insured and insurers were concerned.
Right.
I'm sorry, in relation to the arbitration point I was referring to, that the references, and I can have it added to case lines, is Article 5, Subarticle 3 of the Insurance Authority Board Resolution of number 33 of 2019.
Right. Right.
And it's Mr. Krishnan's evidence on behalf of QIC, paragraph 23.4, that insofar as QIC was concerned, Article 110 was a mandatory procedure for it. It couldn't opt out of that. Insofar as UAB was concerned, it had to litigate by responding to the ruling of the insurance authority once it found in favour of the bank.
Right.
And I referred your lordship earlier to the wording of the insurance, the jurisdiction clause in the CCI policy, page B2 in my skeleton argument, paragraph 6.
Yeah.
And one can see there the reference to the jurisdiction of the UAE court, the selected court. So in my submission, that bolsters the explanation and bolsters the interpretation of Article 110 as conferring only jurisdiction on one court within the UAE, because only one court would be able to consider whether or not a ruling of the insurance authority should be enforced or whether it should be challenged. And
where does that take you? Because there's more than one onshore court, isn't there?
Well, within the one, it would be the federal courts here, and of course the federal courts have their own rules for allocating jurisdiction between themselves. That's my understanding.
You say that the court is the federal court?
Yes, my lord.
Wherever it chooses to allocate the case?
Yes, my lord.
Yeah, all right.
So we say that once that background becomes clear and the mandatory nature of that onshore dispute resolution regime becomes clear, and the back-to-back nature of these contracts and the importance of the back-to-back contract being back-to-back both in terms of the drafting but also the meaning of the terms, the jurisdiction clause in the reinsurance contract simply cannot have meant and cannot have been intended to confer jurisdiction on the DIFC courts. That exposes QIC to an entirely uncommercial level of risk. It's an entirely uncommercial construction of that clause. It simply cannot be right in my submission.
If you're right on that, where does that get us? Let's assume for the moment there's a jurisdiction clause saying onshore Dubai courts, right?
Yes, my lord.
But on one hypothesis, there is the argument that clause the JAL 5A1B is satisfied. Contract partly made in the IFC. What happens then?
Well, my lord, I think that would be setting up my submission is that on the current case law, your lordship would have to follow the wording of the JAL in its unofficial translation, which is that the jurisdiction of the DIFC courts is exclusive.
It's setting up a case for the JJC in due course.
I think, yes. I mean, I can't see, on the basis of the current authorities, I don't think your lordship can get around the exclusivity. Sorry, just 1 second. Someone's handed me a post-it note.
I'm saying don't give in.
It's very difficult when you're communicating via WhatsApp rather than being able to turn around. Of course, my lord, the JAL as originally drafted contained an opt-out provision. Article 5A2 was an opt-out provision.
Yeah, I'm looking at 5A1B.
Yes, but I'm going to see. Just excuse me one. I don't have a copy of the original. Excuse me, just one. My lord, in the original JAL, Article 5A1 provided provided that the court of first instance shall have exclusive jurisdiction over, and then in fact recited the same provisions that are currently found in Article 19(1) of the court law that's quoted by Mr. Craig in his skeleton argument. I will have this original version uploaded to case lines. If you can both take my word for it as I'm reading it from my screen, Article 5A2 of the original JAL provided that the parties may agree to submit to the jurisdiction of another court in respect of the matters set out in Articles 5A1A, B and D of the articles. That was civil and commercial cases involving the centre or any of the centred bodies or establishment, civil or commercial cases arising out of a contract that had been executed or a transaction concluded in the centre, or any application over which the courts have jurisdiction according to the centre's laws and rules. That's what now 5A1A, B, C and E would be. My lord, obviously that's the rule has now been recast as a opt-in provision.
Yeah.
I would invite.
Yeah.
Sorry, I didn't mean to interrupt.
Carry on. You'd invite.
I'd invite your lordship to. I may have been overly hasty in suggesting earlier that there is no room for your lordship to operate Article 5A2 as an opt-out from exclusivity in Articles 5A, 1A, B, C and E.
I didn't understand that because I'm looking at 5A2 and it says nothing about opting out. It's all about opting in.
The drafting of the. I agree. That's the way it's drafted.
I can see an argument if it said the courts of the first instance may decline to hear a case if parties have agreed some other court.
We worth what if one actually looks on to 3, my lord.
What?
You look at 3, but you can see that that's then qualified. That's exactly what it says.
There's 3. 3 of what? Sorry.
So 5A3.
Where do I find that?
That's D280. This below, which provides that the.
Hang on, I've been looking at Mr. Craig's skeleton. D what?
280.
Yeah.
I think that's the closest I can take your lordship to. It's not even really an opt-out at all. I mean, there's no.
Where's it? Sorry, I'm looking for an opt-out.
I think I was hastily reading, and I think is in fact I've led you down a path which doesn't lead anywhere.
Right. Okay. It's not.
If I could just take 1 second just to virtually turn around. Sorry, I am conscious of the time.
Sorry.
I think that's as far as I can take, Your Lordship. But then, in relation to an opt-out, I will have the original JAL unamended added to the back of the defendant's authority section D of the bundle.
And then the unamended JAL, I'll look at it myself, had what you say is arguably an opt-out.
In terms of an opt-out, yes.
Yep.
Now I am conscious that I'm eating into Mr. Craig's time, so I will take the last part of my submissions.
Just remind me what they are.
So the first one is that in relation to the brokers, but you've already, Your Lordship has already asked me about the other connections to the onshore, the UAE, and I've pointed out the role of Aon Middle East, and I've pointed out the correspondence that took place between QIC and Aon Middle East. So I don't think I need to take Your Lordship to that, and you have my written submissions at paragraph 44 of my skeleton argument.
Yeah.
Just dealing with some of the points taken against me, there's a suggestion in some of Mr. Beswetherick's evidence that the lack of any specific discussion in emails or otherwise about the jurisdiction clause in the reinsurance contracts meant that it cannot have meant to exclude the DIFC courts because it has a default meaning. Now, I say that doesn't go anywhere because if there were no discussions, there was likewise no basis upon which the positive assertion can be made that it did include the DIFC courts. A point is then taken that the reinsurance contracts can contain lots of London Market standard form clauses. Mr. Beswetherick says that those sorts of detailed provisions regarding the administration and claims handling procedures would not be familiar to the onshore UAE court or to onshore UAE law. Mr. Craig in his submission says that the onshore courts would be wholly unfamiliar with these sorts of provisions. No evidential basis is put forward at all for that proposition. Mr. Beswetherick also says, and I quote, "Such rules and procedures need to be interpreted in English by a court familiar with such practices and agreements." There's no suggestion anywhere made. First, there's no suggestion anywhere made that the parties wouldn't have been free to agree to submit their jurisdictions to the French courts, the German courts, or any court operating not in English or not in common law. I don't believe that's being advanced, so it takes us nowhere. Secondly, as far as I understand it, it's not being suggested that on the claimant's construction that the jurisdiction clause is exclusive within the UAE. If their point was good, it would have said DIFC courts, because only the DIFC courts would have been able to interpret these clauses. So again, I say that doesn't take us any further forward.
Or the Abu Dhabi court.
Excuse me?
Or
the ADGM
court.
Yes, quite. And then finally, there's then a suggestion that because this case involves a sanctions clause, which concerns, quote, the application of complex UN, EU, UK or US sanctions legislation, it has to be inferred that, quote, the parties anticipated they would use common law courts to determine whether such sanctions legislation is of application. That's Mr. Beswetherick's evidence, his first statement at paragraphs 46 to 48 at page A296 and following.
You made this point in your skeleton.
Yeah, I wish my instructions are to emphasise this point, however, that it would be highly irregular for this court to find that the onshore courts would not uphold and comply with the UAE's international sanctions obligations. My instructions are to make that point very clear that this court should not entertain that submission. It would be completely contrary to judicial comity as between the different courts of the UAE, and it has absolutely no foundation in any of the evidence put forward, and therefore should be entirely disregarded as a factor in favour of the claimant's interpretation of the jurisdiction clause. My Lord, you've seen it, paragraphs 47 to 49 of my skeleton argument, that in terms of the proper construction of the choice of law clause, for the same reasons regarding fronting arrangements, lack of connections to the DIFC, onshore connections, etc., we say that should be construed as a choice of onshore UAE law. I don't.
If you're right on jurisdiction, then it'd be quite wrong for me to try and decide the law of the contract, because I wouldn't have any jurisdiction to do so. If you're wrong on jurisdiction, then do you want, Mr. Craig says, I shouldn't go into proper law because there's more material that might be relevant to it. Do you agree with that position?
Perhaps I'll hear what Mr. Craig has to say on that and get some instructions, because I'm just conscious of the time and allowing Mr. Craig to crack on, if that's acceptable to your lordship.
Yeah, okay.
Thank you.
Thank you very much. Mr. Craig, do you want to crack on, or do you want 10 minutes to get a cup of coffee?
I mean, your lordship's hands, whatever you'd prefer. Would you like 5 minutes just to get a coffee?
You're not. You're going to finish within the time, aren't you? I'd have thought we've covered a lot of points in the argument.
We have covered quite a lot of the ground. I mean, I'm not going to repeat obviously what I said. I do want to go over some of the factual background because it hasn't quite been properly characterised. Right. I want to take you to some of the underlying terms as well, given in particular what's said about single or multiple contracts.
If we restart at 11:30 UK time, would that give you enough time?
Yes. Do I have until 1 o'clock? Is that when we finish?
We must finish at 1. So if you were you able to stop at 10 to 1 to give Mr. Hogan just a chance of coming back on any particular point?
Yes, I'll cut my cloth accordingly.
Right. Thank you. Let's resume in 7 minutes time at past. Thank you.
Thank you.
Hello. Sorry, I kept you waiting. Right, Mr. Craig.
No trouble. Thank you. Obviously, the single question to be determined at this hearing is whether the court has jurisdiction to hear the dispute. There's the additional question which we just dealt with before the short break about what is the governing law. And I've said effectively all I can say on that for present purposes without hearing anything further from Mr. Hogan. I mean, it's just a question which you should not be determining at this stage for the reasons that I've set out. And until anything further is said by Mr. Hogan, there's little point in me dealing further with that point. But for the purposes of my submissions on jurisdiction, I'm going to take it in 2 stages. First of all, I'm going to deal with some of the background to the dispute. And then secondly, I'm going to address each of the gateways upon which we rely in the same order as in the skeleton argument.
Yeah.
Now, first of all, dealing with the factual background, obviously we have an insurer based in Deira, Dubai, and the underlying insured for that policy being United Arab Bank. Prior to the inception of that policy, we say the defendant QIC arranged to reinsure the risk and instructed Aon in the UAE to do so. Now, Aon sought, obviously, to place most of the reinsurance into the London market. And for that purpose, it used Aon UK effectively as a placing broker, because obviously in order to access the Lloyd's market, you need a placing broker. Some of the reinsurance, though, was placed in the DIFC. And it seems likely, we say, that that was placed by Aon DIFC. Now, we are obviously not party to communications between QIC and its brokers, who are obviously its agents, and we don't have a record of such. However, there's an email exhibited to Mr. Christian's second witness statement, which provides some support for what I've just said. If you look at page A532, and apologies while I just flick through the pages to get there.
If you could go to find page.
Yeah, find page, I suggest.
A532, which is an email from somebody at QIC to the loss adjusters dealing with the claim. It's dated the 10th of August 2020.
So how do we know so on as QIC?
If you go down to the bottom of the page, you'll see it's their claims manager, A532.
I see.
The claims manager at QIC.
Yeah.
And you will see reference to refer the various correspondent telecon, etc. in respect of the claim. You've seen no updates in respect of the claim. We're surprised whether the placing broker, Aon UK, is following up with the reinsurers in regard to the payment or keeping silent. So just to be clear there, Aon Middle East would be the producing broker, and then dealing with Aon UK as the placing broker. And then the third paragraph down, you'll see we also advised you've asked HFW to file a case in UAE Court of First Instance against the decision of the Insurance Authority. We're exploring the possibilities of including Aon DIFC and Aon Middle East as a part of the legal proceedings. Now, obviously, we can't take that too far.
Can you just tell me, Mr. Vincent, to whom this is sent, belongs to whom?
He is the loss adjuster acting on behalf of QIC in dealing with the claim brought by UAB.
Right, so Aon are not party to this email?
They're not, no. This is effectively an internal QIC communication.
I see. Yep.
I mean, what it appears to be suggesting, and as I say, we can't take this too far, but what it does appear to be suggesting is there might be claims to be brought against Aon Middle East and also Aon DIFC. And as I say, therefore, we are unable, obviously, to delve into QIC's communications with its agent, its broker, and strong reliance has said Aon DIFC not involved at all. But this does suggest, in fact, that it was involved. And indeed, that would make sense, given that some of the reinsurance was placed, we say, in the DIFC.
Yeah, I see.
In any event, QIC instructs Aon to arrange a reinsurance, and it seeks to do so and negotiates with each of the reinsurers. Now, to be clear, and contrary to what is claimed by the defendants and Mr. Hogan in his submissions earlier, it is no part of the claimant's case or evidence that negotiations over the reinsurance contract took place between the claimants and UAB directly. That is not any part of Mr. Biswetherick's evidence, and there is no evidence to that effect anywhere in the evidence before you. It would also not make sense. It was QIC that was seeking the reinsurance through its broker, not UAB. Now, the consequence of Aon's negotiations on behalf of QIC with the reinsurers is the conclusion of 5 reinsurance contracts providing a facultative reinsurance regime. And essentially it's by way of a 5-layer program. If I can take you to the primary layer, starting at A47. It refers obviously to the fact that it's comprehensive crime reinsurance, and the reinsured are identified as QIC at this point in time, and the contracts are originally concluded, retain 5%, and then obviously mentions the original insured. Now the policy period is the same as the underlying policy, 30 November 2014 to 29th November 2015, and the interest is in 2 parts of the underlying policy. We have a limit of indemnity of 5 million each and every loss, 10 million in the aggregate. And the reason I just draw your attention to that is because obviously in the way these policies work, as we go up the layers, there is a different limit of liability, and then the excess, in this case, is 250,000. But as we go up the layers, the excess is effectively the aggregate or the total of the underlying layers of insurance. So for the next policy, you have an excess of 5 million.
Yeah. Yes.
The reinsurance conditions include what's described as a proportional facultative reinsurance clause, NMA 2977, as attached, which I'll take you to in a second, and also at 6, sanctions, limitation and exclusion clause, also attached. Then the original conditions are wording as attached. And just to be clear, it is not wording as per underlying insurance policy. Now that's important for the purposes of the argument that is advanced, which is these policies were back to back. The reinsurance policies were back to back, as we'll see, and they adopt the same wording. However, this reinsurance policy is not on the same terms as the underlying insurance. We've looked at the jurisdiction clause at A48, and then at A51, you will see the proportional FAC reinsurance slip contract. And in the penultimate paragraph, where headed the underwriters, you will see it says the underwriters, member of the syndicate referred to in the slip, hereby bind themselves separately and not jointly, each for his own part. Sorry, you've got it.
Yeah, you said separately. It said separately. It probably means the same.
Sorry, severally. Yes, sorry, severally and not jointly, each for his own part and not one for another. And therefore, each of the underwriters should be liable only for his own share of his syndicate's proportion of any loss payable under this contract.
Mm-hmm.
So there is a single contract, but there is several liability under it with respect to each of the subscribing reinsurers.
Yeah.
Now this clause, just to be clear, is incorporated in every single one of the 5 reinsurance contracts.
Mm-hmm.
And of course, what it does mean as well, in addition to the fact there's a one contract containing several liability, is that payment by one reinsurer is not an admission by another reinsurer that it's liable for the claim. And then A53 is the sanction, limitation and exclusion clause, which says no reinsurer shall be deemed to provide cover and no reinsurer shall be liable to pay any claim or provide any benefit hereunder to the extent the provision of such cover, payment of such claim, etc., would expose that reinsurer to any sanction, prohibition, or restriction, etc. So the point of that clause is each separate reinsurer has to have regard to its own sanction position. It is not correct to say, as was argued, that Zurich have accepted or agreed a different construction of this clause to all the other reinsurers. Not at all. The point is each separate reinsurer is potentially exposed to different sanction regimes, and in this case, the claimants are all directly or indirectly owned in the US, with the consequence that sanctions which apply there affect them, but they don't affect some of the other or the other reinsurers under the 5 layers. And that is why they have paid out. The second point to make about this sanctions clause, which rather puts paid again to the back-to-back argument advanced by QIC, the underlying policy does not contain such a provision. There is nothing in the QIC policy about sanctions.
Mhm.
And of course, given that is central to what we are talking about in this dispute, and the allegation that effectively you'd always have the argument that's put forward is that there are cut-through agreements so that the reinsurers always have to pay. Well, that's not the case here, because obviously there is no sanctions exclusion in relation to QIC's liability under the underlying policy.
Do we have the underlying policy in the bundle?
We do. It is at, sorry, give me 1 second. It is at A, sorry, give you 1 moment. I'm just trying to precisely locate it. A343.
Thank you. Yep.
In terms of the participation in this
So
layer,
A343, if it was on the first page, conditions, number 4, sanctions, limitation, and exclusion clause.
A343. Yes, but it doesn't seem to be. We haven't actually. It doesn't seem to be actually incorporated or included in the policy we've got.
Yeah, just for your submission that it didn't include a sanctions clause.
Yes, yeah, agreed. But in any event, the point is that it can't. Ultimately, it won't be. It can't possibly be back to back in the way that's alleged, because obviously the reinsurance agreements provide that each reinsurer has to investigate its own individual position.
I follow that. Yeah.
Yes. Yeah. Yeah. Apologies, I hadn't noticed the condition at 4. Going back to the primary layer, the participation in the policy and the reinsurance contract rather starts at A129
Mhm.
And this is the signature of Swiss Re.
Yep.
First of all, 60% ultimately was written down because there was an oversubscription. But just a note, the stamp and signature of Swiss Re was applied on the 26th of November 2014. That is before the reinsurance contract incepted.
So 2014.
26th of November 2014. You see the scratch.
Yeah.
Beside the stamp. 26th November 2014. So in other words, that's before the reinsurance contract incepted. All of the signatures and the stamps that were applied by the participating reinsurers were applied on either the 26th or the 27th of November 2014. So all of the reinsurance contracts were agreed and concluded before the inception of the underlying policy. That is contrary to what is stated by the defendants in their skeleton argument at paragraph 7.2 and also in the statement of Mr. Krishnan.
Yeah. When did the underlying insurance come into force?
The 30th of November. As did the reinsurance contracts.
Yeah.
I mean, and just so we can see at page 130, we have Jules participation representing a number of different Lloyd syndicates, and you'll see all the dates there of the 27th of November. And also at 131, another dual thing on the 27th of November 2014. We then have at page 132 the line written by AIG Europe Limited, who is the first claimant.
Yeah.
Again, see it says agreed on 27th November 2014.
Yeah.
And then at page 133, you see the signature and stamp of Zurich Insurance Co Limited DIFC branch on the 27th of November. Now, just to be clear here, Zurich DIFC was not acting as agent in any way for some other entity. Zurich Reinsurance Co Limited DIFC branch is a branch of Zurich, which has its own underwriting capacity and was underwriting and reinsuring this policy itself, not on behalf of anybody else.
So if Zurich had not paid out or and had been a party to these proceedings, it would have been Zurich DIFC branch.
Correct. That, of course, is a distinction between it and Talbot, who is the third claimant, who was represented by its agent, Talbot DIFC, in concluding the reinsurance contracts on its behalf.
I see.
I don't think it's necessary to take you to the first excess layer, which was to which Swiss Re was the only party, but that provided cover of 2 million with an excess of 5 million.
Yeah.
In other words, as I said, the primary has to be extinguished before you get into that next layer. The second,
have you got a page reference just without turning up?
Yes, it is at A136.
Thank you. Yep. Second excess.
The second excess is in bundle is in tab F1.
Yeah.
And again, starts F1, contract of reinsurance, and then we have at page F4 something which is very similar to the primary layer which we looked at. In it, and you'll see that here the limit of liability is 8 million, but the excess is 7 million.
Yeah.
Because obviously that you have to satisfy the first two layers, the 5 plus the 2, before you get to this.
Yeah.
And you will see at page F5, the original conditions are to follow all terms and conditions of primary policy B0, etc. And that is the primary layer that we looked at a moment ago. So in other words, it is back to back with the original primary layer policy.
So where am I looking at for that? Oh, I see. Sorry, section 1.
1 and 2, original conditions, to follow all terms and conditions of primary policy number, and then it gives a number.
Yeah. Mm-hmm.
And you'll see it has the same jurisdiction clause.
Except for the lack of united, but apart from that, same.
Exactly. Yes, exactly. About where I understand there's no issue, but that makes no difference. And then F25 for this one, you see that Zurich DIFC on its own behalf is the lead reinsurer.
Yep.
And that's no doubt why its stamp occurs on, by the look of it, every page of the reinsurance contract. At page F26, you see the stamp and signature of Talbot Underwriting MENA Limited, registered by the DFSA. That's a 30% line. Like Zurich DIFC, Talbot was at that time a licensed DIFC establishment. This stamp, though, has to be read with the binding authority, which we have at F30. And you see that it says that effectively Tumina DIFC acts as agent for the insurers on risk for all purposes, including but not limited to the issuance of certificates, endorsements and policy wording, and collecting and processing of premiums. It doesn't act for any other party, including clients, etc. And then it says the next, all Tumina clients and or their agents agree to be treated as professional clients as defined by the DFSA and must act at all times with utmost good faith towards Tumina and insurers. So in other words, with respect to this, to Talbot DFSI's obligations, it owes regulatory obligations in the DIFC under the DFSA rules, and obviously its clients also owe corresponding obligations in return in the DIFC.
Mm-hmm.
And then you can also see that the insurers for whom it acts are identified as the third claimant, Talbot Underwriting Limited, Syndicate 1183 at Lloyd's. And then you'll see in relation to claims, it says, in the event of a claim being made under this insurance, please ensure notifications are made to MENA claims at, sorry, I can't read the talbotunderwriting.com in order we can notify and seek underwriters' instructions. So in other words, any claims brought under the policy are to be brought to Talbot DIFC.
Well, notification to Talbot.
Yes. Yeah, notification, etc. That is going to be brought in the DIFC.
Going back to page 26.
Yes.
There is nothing to indicate in Talbot's signature that they are acting as agent. Is that right?
Not the signature alone. No.
We simply know that from the terms of page 30.
Yes, which forms part of the reinsurance contract.
As part of the reinsurance contract.
It's all part of the reinsurance contract. Yes, so this is attached as part of the clip, if you like, of the contract.
So it's not a case of an undisclosed principle. It's disclosed because page 30 is attached to the contract.
Precisely.
Yeah. Okay.
And just in relation to the further participation, F27, in relation to this policy, we have Markel, who's the second claimant, and you can see that it agrees to write 10% on the 27th of November 2014.
Yeah.
And just below that, you can see the agreement of Berkshire Hathaway on the 27th of November to write 7.5%.
Yeah. It was oversubscribed and all written down.
Correct.
Yeah.
Precisely. Yes. The third excess layer, and I'm not sure it's necessary to take you to it.
You just give me a page reference.
It's A190. And it provides for a 15 million limit, excess 15 million. Like the policy we've just looked at, it follows the primary layer, has a jurisdiction agreement with the word United inserted, and the participation includes, in addition to the first claimant, Zurich DIFC, who signed. And that's A216. I don't know whether you'd like me to. Would you like me to take you to that?
I'm just looking at the talk.
Yes.
Yep.
So A216 is where Zurich DIFC signed the third excess layer, and you can see again it signed it on the 27th of November 2014. And A217 is AIG, the first claimant's 30% line.
Yep.
And then finally, we have the fourth excess layer, which is a limit of 20 million, excess 30 million. Again, the same terms as the third excess layer. Original conditions follow the primary layer.
Page.
Sorry, the excess layer starts at A221. And that term about original conditions following the primary layer is at A222, as is the jurisdiction agreement. The participation on this one, A242, is Talbot's stamp, and it scratched this policy as lead.
So say it again.
So it was the lead for the fourth excess layer.
Yeah.
and it had attached, again, as part of that reinsurance contract, the binding authority, which we looked at in relation to the second excess layer.
So we know it's the lead simply because its signature comes first.
Yes, and also I'll show you in a moment the fact that when endorsements are sought to change the percentage that QIC is taking, only the leads sign up to that, and Talbot does so on behalf of the reinsurers for the fourth excess layer.
Yep. Mm-hmm.
And in addition, so just for your note, again, the binding authority in relation to that contract is at A247. It's in identical terms to the one we looked at for the second excess layer.
And Zurich is on 245.
And Zurich is on 245, precisely. Signing on the 27th of November 2014.
Yeah.
So as I said, originally QIC retained 5% of the risk, but the contracts were amended on the 1st of December so that the risk was 100% reinsured. And those contractual amendments can be found at
what date was that?
1st of December 2014.
Yep.
And you will see those contractual amendments in relation to each of the layers start at A515.
Mm-hmm.
And the first one is signed. You will see at 515, it says it's agreed that the following amendments are included under this policy. The reinsured QIC who retain nil. So it's now 100% of 100%. And you see the contract endorsement at page A516, which is just signed by Swiss Re.
One knows is his first layer from the policy number, is that right?
Yes.
Yeah.
Yes.
Yeah.
517 is the same, but with respect to the first excess, which again is Swiss Re on its own. The third one at 519 is the second excess layer, which is signed by Jewel as lead.
Mm-hmm.
And then 521 is signed by Zurich as slip lead on the third excess layer. And you can see at page A522, it's stamped, signed as slip leader.
Yeah.
And then at 523, we have the fourth excess layer, and you will see at 524, it's stamped by Talbot Mina. In other words, Talbot DIFC. A slip leader. So these are amendments to the contract being agreed. And we would say that this one that we're just looking at, 524, stamped Talbot Mina, and also the one at 522, which is stamped by Zurich DIFC, are concluded and can only have been concluded in the DIFC. So those are the reinsurance contracts. There's no dispute, obviously.
You say that on the basis that there's no evidence that they were concluded elsewhere and that these were both DIFC entities.
Yes, they were only regulated and permitted to carry out insurance business in the DIFC.
Yep. Thank you.
As I say, that there's no dispute that an indemnity was sought by UAB under the policy with QIC following its payment to the underlying customer. And then UAB commenced proceedings in the civil courts of the UAE in May 2020. Before it did so, each of the reinsurers who are the claimants in these proceedings made clear they could not and would not provide an indemnity under the reinsurance contracts by virtue of sanctions, and they placed reliance upon the sanctions clause. And I'll just show you an example of that. If you look at page 485 of A, bundle A, A485, you'll see an email dated 27th of January 2020. So this is several months before UAB brought proceedings in the courts, the civil courts in the UAE. And you'll see that Markel this is the email from Markel, the second claimant, and outlines their understanding of the background in relation to the insurance claim, refers to the reinsurance policy, and identifies expressly the sanctions limitation clause. It then identifies the fact the claim result of an employee colluding with a third party, etc. And then says Alpine is organized under the laws of Hong Kong and is wholly owned by 3 Iranians. And then position of Markel, reinsurance policy sanctions limitation excludes the liability of a reinsurer to provide or cover, etc., etc. And then it says Markel organized under the laws of England, but indirectly wholly owned by a US company, and then as a result, as a US company, prohibited from directly or indirectly providing insurance services to persons ordinarily resident in Iran, etc. And then payment of the reinsurance claim would amount to the prohibited provision of insurance services, etc. And then payment of the reinsurance claim would expose Markel to a sanction, etc. And then it says obviously without prejudice to other positions, etc. But the reason I take you to that is because contrary to what is stated by the defendant in its skeleton argument, QIC was in no doubt about the position of the claimants on the claim throughout the currency of the proceedings in the civil courts of the UAE. There's no suggestion that it can possibly have thought that it was going to be covered for the claim. Now, with that background in mind, I now turn to the question of whether or not this court has jurisdiction. And there are 2 parts to our case on this. The first is obviously that the court has exclusive jurisdiction under Article 5A1. And the second is that the court has jurisdiction because the parties have opted into it under Article 5A2. Now, 5A1B, I've set out at paragraph 13 of my skeleton argument, and it's also at D279. And I don't think I need to take you back to it. And obviously, both of us have quoted paragraph 60 of the judgment of the Court of Appeal in Al-Khorafai, which basically summarizes what is the test under this section. But what I should point out at the outset, though, is there is no requirement for there to be a meaningful relationship between the DIFC and one or more of the parties to the dispute. That is what Article 5A1A is directed at, which requires that one of the parties be, for example, a DIFC, a licensed DIFC establishment. That is not the test under Article 5A1B. And what you are looking for the purposes of a necessary connecting factor under Article 5A1B is a contract which has either wholly or partly been negotiated in the DIFC, wholly or partly agreed in the DIFC, or wholly or partly performed in the DIFC. And we say each of those requirements is satisfied. And the first reason for that is because Zurich DIFC, a licensed DIFC establishment, was and is a party to all of the reinsurance contracts. Zurich DIFC is a regulated entity obliged to operate in accordance with the DFSA rulebook. And under, I don't think I need to take you to it, but under the general module 2.2.2, effecting, that's E195, I don't need to take you to it, effecting contracts of insurance and carrying out contracts of insurance constitutes a financial service under DIFC regulatory law.
Hang on a second. Which 2.2.
2.2.2.
And L, I suppose. Was it L in particular, or was anything else? M.
L and M. It's the effecting and carrying out, the two we rely upon.
Yep.
Now, Zurich DIFC was based in the DIFC. That's the only place it's authorized to operate. Accordingly, we say the contracts were partly negotiated there and partly agreed there. It signed, as we've seen, each of the reinsurance contracts. And it also negotiated and agreed the endorsement to the second excess layer as lead, which we have also looked at.
Yeah.
The second point in support in relation to this, which is separate, I mean, if you don't accept what I say in relation to Zurich, this suffices. Talbot DIFC entered into the second and fourth excess layers in the DIFC as agent for the third claimant. Now, one doesn't look at the place where the principal is located to identify where the contract was concluded. You look at where the negotiations for that contract took place and where it was agreed with, where you have an agent involved, where the agent is based. And as we've seen, Talbot, like Zurich DIFC, was authorized to operate only there. And as we looked at that binding authority, it made clear that basically its contracts were subject to the regulatory authority of the DFSA. And Talbot equally agreed the endorsement to the fourth excess layer as lead insurer, as we've seen. And finally, contracts were at least partially performed in the DIFC, because each of Zurich DIFC it has to be paid in the DIFC, and as we've seen under the binding authority, Talbot DIFC acts as agent for the third claimant in relation to the receipt of premium. And equally, we say that claims notifications have to be made in the DIFC, at least with respect to Talbot. And again, that is at least partial performance of the contracts.
Can you just help me on just a reference? Don't turn it up. Do we have in the bundle something, some certificate showing the registration in the DIFC of both Zurich DIFC and Talbot DIFC? It's not in the anything.
But we do have that for Talbot at A523, I think. Can I come back to you on that?
Yeah, sure.
I just want to check the references. I'll get those behind me to check the references.
Yep, thank you.
I mean, if need be, it's a matter of public record, which one can obviously obtain if necessary.
I don't think it's in dispute, but it's just useful to have the reference.
That deals with 5A1B.
Does it cover C as well?
No, C we say is slightly different, and that at C that I refer to.
I've lost the page for that. For the
is at C9 of my skeleton.
Yeah, is it in the bundle?
Yes, it's D279.
No, I didn't mean your skeleton. I meant the JL.
Yes, it's D279. The reference to the D279 is where 5C is.
Thank you.
And in my skeleton, I referred to the decision of Justice Roger Giles in Mazoon Holding LLC and Arif Naqvi. That is at E131.
Yeah.
And you will see at paragraph 6 at page 132, the reference by the judge to the claimant's reliance on the gateway in Article 5A1C. And then at paragraph 7, he says there are two limbs of the gateway which must be satisfied. First, that the claim or action arises out of or relates to an incident or transaction which has been wholly or partly performed within the DIFC. And secondly, the incident or transaction is related to the DIFC activities. And then they refer to the decision in Al Korafai and Bank Saracen Alpen, where the Court of Appeal said of the requirements that in relation to the meaning to be accorded to transaction is in any commercial relationship between the claimant and the defendant giving rise to mutual rights and obligations, including but not limited to a contractual relationship. Whether it's meaningful to speak of a transaction as being performed in a particular place, that is not so of an incident. And then the requirement that such transaction or incident shall be related to DIFC activity simply means such incident or transaction should have been in furtherance of or as a result of particular commercial activity carried on in the DIFC. And then it says, while these remarks in part spoke of a cause of action in tort for breach of statutory duty, applicable also to the essential elements for a contractual cause of action or a claim to equitable relief. Now, this is concerned with performance of the contract, and we say it was at least partly performed in the DIFC for the reasons I have said, and it's related to DIFC activities in part because it involves licensed DIFC establishments.
The performance is payment of premium and negotiation and conclusion of the contracts.
Yes. And the notification of claims, or notification of bringing a notification of claims and dealing with claims.
So, and then that's partly performed, and you say the DIFC activities is the activities of a registered insurance practitioner. Yeah.
That concludes on 5A1C. Then it's 5A1E. That is in my skeleton set out at paragraph 20, and it's also in the bundle at page D280.
Yeah.
And that's exclusive jurisdiction to hear and determine any claim or action over which the courts have jurisdiction in accordance with DIFC laws and regulations. Now, there are two bases upon which we say that jurisdiction is found under this head. The first is we place reliance upon RDC Rule 20.7.
Give me a second. Is this a necessary and proper party thing?
Yes, exactly right. And that rule, I'm going to take you to the decision of the Court of Appeal in Nest Investment, which is at E92. And this was an appeal against a decision of the Court of First Instance, where it was found that there was no jurisdiction under RDC 20.72 to order the joinder of the second defendant, where the claim against the second defendant didn't fall with any of the gateways, Article 5A1A to D of the JAL.
Right.
And you will see at paragraph 17 of this judgment, first of all, the recitation of the rule at 20.7. This is E96. The court,
Yeah.
and I'm taking it's just convenient to take you to this in the judgment rather than taking you to the rule and bringing you back into the case. The court may order a person to be added as a new party if A, desirable to add a new party so that can resolve all matters in dispute, or there is an issue involving the new party and an existing party which is connected to the matters in dispute in the proceedings, and it's desirable to add the new party so the court can resolve that issue. Now, at paragraph 50 of this judgment, which is at page E102.
Yeah.
I just going to, if I may, take your lordship through this bit of the judgment. It says, just as the CPR has the force of the statutory instrument which enlivens them and gives a discretion to the English court, which is thus enabled to make rulings in respect of entities under a form of long-arm jurisdiction, which might not always be recognised by foreign courts, as also Article 5A1E, by reference to DIFC regulations, allows DIFC regulations in the form of rules of court to create a discretionary jurisdictional power in the shape of RDC 20.7. Can be no reasoned objection to a jurisdiction created by the rules of court authorised by statute to do so, etc. And then paragraph 52, he says the indisputable fact is the wording of RDC 20.7 is wide enough to confer jurisdiction upon the court by giving it the power to make the order in question if the criteria are satisfied. The words give the court the discretionary power to allow joinder in the circumstances outlined. Whilst not expressly conferring jurisdiction by using that terminology, the rule makes no reference to a requirement that any of the Article 5A, 1A to D gateways should apply, and for the reasons given above, were it not to confer jurisdiction, the rule will be robbed of most of its force. And in such circumstances, question of policy and purpose in the rule in question and the rules as a whole fall for consideration. There are overwhelming reasons for the court to give the rule a wide meaning. There is self-evidently merit in a court having something in the nature of a necessary or proper party rule, so that matters in dispute can be decided between all the relevant parties without the risk of inconsistent decisions by different courts at different times, with all the inherent additional cost and convenience involved. As the claimants point out, the effect of the refusal to make an order in a case of the present is to render the DIFC courts effectively incapable of trying a claim with multiple defendants from different jurisdictions, where the gateways cannot be satisfied in respect of each. Public policy weighs heavily in favour of the court having such a power because it aids in the administration of justice, a power found in the rules of court in many jurisdictions, however differently it may be expressed. The object is to prevent unnecessary duplication of litigation in different jurisdictions and to facilitate the resolution of disputes consistently between multiple parties where common issues arise for the determination. Overriding objective, as expressed, enable the courts to deal with cases justly, etc. And then, in the view of this court, the narrow approach for which Mr. Al-Fadi contends would run counter to that objective. So, what we say is,
this enables you to add claimants as well as defendants. Is that right?
Yeah. Yes, because we would say they are necessary for parties to the dispute.
That's different from what used to be the English position. I don't know whether it still is. When I practiced in England, you could only add a defendant, but no doubt you can add claimants as well nowadays.
Yes, sir. You could bring in. Well, obviously, you can add claimants as and when you wish. But I mean, it says it's a what we say in reliance upon this is that if you consider that Talbot falls within the gateways of B and C, but that doesn't give jurisdiction with respect to the other claimants.
You can add them under this rule.
And we say we add them under this rule.
Yeah.
And the reason we say that is obviously there is otherwise a very real risk of inconsistent judgments between the various reinsurance contracts, and even potentially as regards between reinsurers under the same contract.
Yeah. Yeah.
And the second ground under Article 5A1E is our reliance upon Article 19 of the court law, which I set out at paragraph 22 of my skeleton, and it's at D192 of the bundle.
Mm-hmm.
Now, Mr. Hogan submitted that you can't possibly have any reliance upon Article 19 because you must have regard only to the JAL as being the authoritative pronouncement of what the law is. With respect, that is not correct. If you look at the decision in Credit Suisse and Goal in the Court of Appeal at D142,
D142.
D142, and if I could just take you back to D141, paragraph 20, you will see the Court of Appeal refers first of all to this provision, Article 19, and then at paragraph 22 at the bottom of page D142, it says the jurisdiction defined by Article 5 of the JAL is not entirely congruent with the jurisdiction conferred by Article 19 of the court law. That difference is picked up by Article 5A1E, which allows for jurisdiction over claims or action to be further defined by DIFC laws and regulations. The parties, however, seem to be agreed is not applicable in the present case. So we do say that one has regard to Article 19 of this provision.
Because the incongruity is solved by the provision in the DIFC court rules, which allow. I see.
To the extent there's any incongruity, I mean, I've already submitted to you, I think, that we say we come fairly and squarely within the ambit of Article 5A, 1, B or C. But to the extent that we don't, there's a very slightly different rule under 19B, which is civil or commercial cases and disputes arising from or related to a contract concluded or a transaction concluded by any of the centre's establishments or the centre's bodies. Now, no requirement there that that centre establishment or centre body be a party to the proceedings. It is simply that there is a need for there to be a dispute arising from a contract concluded by, in this case, we would say, a licensed DIFC establishment.
I see. An establishment means
the centre's establishment includes DIFC licensed establishments. I'll give you the reference for that if you'd like me to.
Yes, please. Yeah.
I'll just ask, if I may, for the reference to be given.
Yes.
I think it might be Article 2 of the JAL. I think that's a guess. Well, an educated guess.
Right.
Can I come back with that reference?
Yes, of course.
If that's all right. So anyway, we say, therefore, there is jurisdiction under this provision as well for those reasons.
In fact, yes, Mr. Hogan's right. Definition of DIFC establishment: any entity or enterprise established, licensed, and so on to conduct any activity in DIFC according to DIFC laws and so on. So I think that
Great.
Probably counts. Yep, thank you.
So moving to 5A2, you looked at the wording it's set out at paragraph 25 of my skeleton. And for the purposes of summarising the position as it stands under DIFC law, we say that all of the relevant principles and key parts of the relevant authorities are neatly summarised in the recent decision of Justice Roger Giles in Al-Bahara. Now, that decision is in both our bundles, but you may have looked already at D172. And just to be clear what this case was about, this was a case by an insurer, not a reinsurer, an insurer against insured for declarations in the DIFC court. And the provision in the in the contract provided, as you will see at page 174, paragraph 6. Contract governed by English law, each party agrees to submit to the exclusive jurisdiction of the United Arab Emirates. Now this, bear in mind, is a contract of insurance, not reinsurance. And we'll come on to the decision in relation to Article 110, etc., that you referred to. But the long and short of it is the submission that's been made to you about the effect of Article 110 and how it provides for exclusive jurisdiction for insurance contracts under civil law. It was not what this decision found. And in fact, it found that that you could bring proceedings on an underlying insurance policy, which was provided a jurisdiction term in these terms in the DIFC. Now, at paragraph 8, you will see the judge refers to the fact that jurisdictional choices in terms such as Dubai courts, courts of Dubai or courts of UAE, etc., considered a number of occasions. And then at the end of the paragraph, he refers to the fact that courts of Dubai, courts of United Arab Emirates considered an IGPL, as later described, held it conferred jurisdiction on the DIFC courts. Paragraph 9 refers to the decision in Goal. The court said it's a constitutional fact. Courts of Dubai are rated by laws of the Emirate, etc. Sorry, Baloo.
I think we've looked at 9 already.
Yes. And then the fact it was endorsed in Larbica. And just to highlight the fact that in Larbica it was said the normal meaning of those words is to confer jurisdiction on the DIFC absent constructional indication to the contrary, whether from the text of the contract or surrounding circumstances. And then in paragraph 11, he referred to the fact that that reasoning of Larbica equally applicable to a clause opposing jurisdiction in the courts of the UAE.
Yeah.
And then at paragraph 12, he determined, in short, the agreements in the policies on the jurisdiction of the courts of the UAE in their ordinary meaning confer jurisdiction on the DIFC courts as courts of the UAE and a specific, clear and express provisions in that respect, unless there's a reason from their text or the surrounding circumstances to give them a different construction. Now, just while we're in this authority, I don't have to come back to it. You will see that at paragraph 20, D176, the second limb of the submission was rather protean, but in debate at the hearing took shape. It was said ADNIC's insurance activities in the Emirates were subject to the law on the regulation of insurance operations, federal law, etc., and the dispute resolution procedure in its Article 110, which is what we've just looked at. The argument then went the dispute resolution procedure involved a first decision by the insurance authority, which could be challenged in a court. The courts would receive a challenge with the onshore courts. Against that background, the parties would have intended the onshore courts would deal with their disputes. Implausible should have been a choice in favour of the DFC courts as an offshore court. Refer more detail to insurance law in connection with abusive process. As there explained, the dispute resolution procedure deals only with an insured taking a complaint to the insurance authority, and even as such a complaint provides for a challenge to go in translation to the competent court of first instance. This is not limited to the onshore courts, is open to the parties to choose their court or courts of competent jurisdiction, and I see little weight in this in excluding the offshore courts from their choice. In that regard, the submission included DFC courts would not receive a challenge as it was put because of the force of Article 4.4, etc. At best, I understand the argument. It was said the exclusion of other insurance business of the DFC evidence a policy, regulation, enforcement of the other business and dispute should be excluded, with the result the DFC courts could not hear a dispute arising under or in relation to insurance, onshore insurance. Submission became quite confused, etc. The confusion reveals a difficulty in the argument. It is enough I'm unable to see that restriction on insurance business in or from the DFC has any bearing on the ability of the DFC courts to hear insurance disputes if the parties to the insurance contract agree that it can do so. Now, obviously, my lord, the reason I take you to that passage is because it runs entirely contrary to the submissions that have been made before you on behalf of QIC at this hearing in relation to how the dispute resolution procedure in onshore, if you want to use that word, Dubai or other parts of the UAE operates.
Yeah.
Anyway, going back to the question before you, your lordship, the only question really you have to decide is whether there's something in the text or the surrounding circumstances which suggest that a different construction to the words courts of the United Emirates should be given to limit them, as claimed by the defendant, to the federal courts, I think was the submission, of the UAE. Now, there are a number of reasons why we say there is no such thing, and to the contrary, the wording suggests the opposite. I'm conscious that I'm slightly running out of time, so I don't want to repeat very greatly what I've said in my skeleton argument, but the first point we make is that the text of the reinsurance contracts reinforces the starting position, namely that jurisdiction is given to the DIFC courts. No attempt is made in the exclusive jurisdiction clause to distinguish between civil and common law courts of the UAE. Mr. Hogan's submission that what was meant was the federal courts of the UAE is of itself misplaced, because that doesn't cover all of the potential courts in the UAE, because of course Dubai, Abu Dhabi, and I understand Ras Al Khaimah have their own court system.
Yeah.
The second point to make about the text is subparagraph 4 of each of the agreements, and I've dealt with this in my skeleton argument at paragraph 32. But essentially, what we say is there's a prohibition on the bringing of proceedings outside the country of the UAE, but there is no prohibition on the bringing of proceedings in the UAE, in anywhere in the UAE. Now, obviously, given that the DIFC is in the UAE, there's no contravention of the prohibition. And that suggests that the bringing of the proceedings in the DIFC is permitted, because obviously the purpose of that clause, subparagraph 4, is to prevent the bringing of proceedings outside the agreed jurisdiction.
Yeah.
The second point we say in support of our, there's no constructional indication to the contrary, is that, as we've said in relation to 5A1, all the reinsurance contracts have a connection to the DIFC because of the fact that Zurich DIFC and Talbot DIFC are licensed DIFC establishments, contracts partly concluded there and partly performed there. In any event, the absence of a link to the DIFC court is of little significance under Article 5A2. And that's a line of authorities. And again, just for your note, that is what is said at paragraph 16 of Al-Bahira at E159. You have the point that all the reinsurance contracts incorporate, they're in English, and they incorporate some standard market terms, which we say indicates that the parties were at least intending that a international court could be a place to which they could submit their disputes.
Yeah.
Now, in the skeleton, obviously, the defendant makes much of, or seeks to say, that the reinsurance contract must have been back to back with the underlying policy, and the jurisdiction agreement must be read in the same way. But there are a number of fundamental problems with that submission. First of all, the reinsurance contracts were not back to back with the underlying policy, as we've seen. Secondly, much was made of the alleged hold harmless agreement, which it says QIC concludes with reinsurers, whereas as the fronting reinsurer. That's Mr. Christian's evidence at paragraph 23.1. However, the difficulty for them in that regard is that no hold harmless agreement was concluded in this case. So in other words, they haven't followed their normal practice. Secondly, and in any event, the hold harmless agreement, which they say they regularly conclude, says nothing about the jurisdiction in which proceedings could be brought. The hold harmless agreement is at page 525.
So D, no, sorry,
A 525, apologies, yes.
This is a standard standard form hold harmless agreement, is it?
This is what Mr. Christian says is the standard hold harmless agreement, which they conclude with reinsurers and underlying insureds, where they're fronting more often than not. But as I say, it's irrelevant because in this case, they didn't conclude it. But you will see that it simply provides that it says the assured firm, who is the underlying insured,
the underlying insurer,
accepts that if any claim or part of any claim made by the insurer in accordance with the reinsurance agreements relating to original policies not paid by the reinsurer, insured firm will not pursue against the insurer the corresponding claim or any other claim under the policy. And subclause 3, the assured firm agrees that the receipt by the insurer of any claim payment or any claim payment under reinsurance shall be a condition precedent to the liability of the insurer to make the corresponding payments under the original policy. So basically what it's saying is the underlying insured will not sue the insurer if it hasn't been paid by the reinsurer. It says nothing about where proceedings might be brought by the insurer against the reinsurer.
Yeah.
The third point to make in relation to what's said by the defendants is their misplaced submission that because the underlying insurance contract provides that any disputes arising out of this contract are subject to the exclusive jurisdiction of the UAE court, that means, therefore, that it can only be what he describes as the onshore UAE court and excludes the UAE. But as we've seen in Al Bahira, that is not the effect of the regulations in connection with the underlying insurance. In relation to the knowledge or otherwise of the brokers, we say that's irrelevant because they are agents of QIC. And indeed, to the extent that Aon had knowledge of the need for jurisdiction clauses to be back-to-back, such that any proceedings needed to be in the same court, that was a matter for them to include suitable wording. So I think that concludes my submissions. I'm sorry, I've rather cantered through at the end to the time. I do apologise for that.
Not at all. They're all set out helpfully in your skeleton argument in any event, but that's helpful. Thank you very much. Mr. Hogan, 5 minutes or so.
There was one. I was going to make one proposal, just to I'm conscious of the time. In the time that Mr. Craig's been speaking, I've been able to dig into the opt-out point a little more. There are a couple of cases I'd want to refer to, but I wonder whether the easiest thing might be for us to, Mr. Craig and I, to sequentially exchange each of us a very short note on those points, because I'm conscious of the time, and it may be that your lordship would benefit from having in writing the relevant references.
This is on the question of the opt-out before the law has changed.
No, the opt-out now. There is an opt-out. I was hasty in my submission, and there's a number of cases which have confirmed there's an implied opt-out within 5A2, but I don't think I would be doing. I wouldn't be being fair to Mr. Craig in springing those on him now. There's I wouldn't want to do that, but hence why I'm wondering whether a very short exchange of notes, I'm envisaging no more than 2 pages in length, would perhaps be more useful for your lordship than me trying to hammer through them right now and not giving Mr. Craig an opportunity to respond.
You object to that, Mr. Craig? If I limit the time for doing so to Mr. Hogan must do it by noon tomorrow and give you till noon the next day? No more than 2 pages?
Yes, I mean, it's unfortunate it wasn't raised, obviously, earlier, and also it's obviously going to increase costs, but there we go.
Well, I think if there's something that Mr. Hogan, I don't want to shut him out. Therefore, Ms. Hogan, I'll give you till noon tomorrow to make sure that you've communicated with the registry and Mr. Craig and sent something no more than 2 pages with references to any authority you want me to look at. And then Mr. Craig can have till noon the following day, which I suspect is a Saturday. He can have till noon on Monday.
I'd be grateful to Monday. And could we just make sure it's limited just to this opt-out point?
It's limited to the opt-out point.
It will be referring to, I think, 2 pages of a book and 2 cases. That hence why the 2-page limit.
Right.
2 minutes.
You make sure that any authorities are also lodged in due course on the case lines.
Yes, my instructing solicitors are already putting up as we speak. The only points I wanted to, given the time, very quickly, the only point I think I'd want to point out is that the suggestion is that Mr. Craig's submissions that the contracts weren't back to back between the reinsurance contract and the direct insurance contract, because Some of the terms weren't back-to-back. Well, your lordship picked up on the prejudice that the back-to-back arrangement is meant to prevent, and that's divergent and conflicting decisions. Therefore, the key question and the key focus for my client was on whether the jurisdiction clause and the choice of law clause were back-to-back. That's the point of the back-to-back arrangement, is to ensure that only one court applying one law will come to a decision as to whether or not there's liability under both contracts. That's the very simple point to that. And I don't think I was going to reply on anything else other than the opt-out. Well, to bring in the opt-out point, but I'll deal with that in writing.
The only thing you were going to tell me about was whether you agreed with on the proper law thing, that if I held there was no jurisdiction, I shouldn't deal with proper law. Obviously, if I held there was jurisdiction, I should leave it over to be decided at the appropriate time.
Yes, I've taken instructions, and I adopt the same position as Mr. Craig in that regard, that if the court doesn't have jurisdiction, you should leave that question alone.
Yeah, and if I do, I should leave it alone for the moment. Yes. Very well. You've both given me cost schedules. Are you asking me to deal with costs or get them taxed, get them assessed by the registry?
I need to take instructions, I'm afraid.
Yes, so did I. I hadn't anticipated.
You hadn't anticipated what?
My recent experience of some of your colleagues has just been for the assessment to take place without submissions, and for the assessment just to be added to the end of the judgment.
You're happy for me just to deal with it, or the question is whether you want me to deal with it summarily, or whether you want me to refer it to the registry for taxation.
I've just received instructions that my clients are happy for your lordship to summarily assess them as part of his judgment.
Same with you, Mr. Craig.
I'm sorry, I'm just waiting for instructions. Yes, we're happy with immediate assessment.
Yeah, very well. So immediate assessment. Right. Well, unless there's anything else either of you want to raise, that concludes the hearing. Thank you very much for your help. I'm afraid we've galloped at the end, but partly because we spent the first 25 minutes dealing with the expert evidence point, which I'll deal with in due course. But thank you both for your help, and it's been a pleasure to have an interesting case to deal with. So thank you.
Thank you very much.
Well, thank you, my lord.